দিল্লিতে বসে না, দশটা বসে না,
সেটা তো এতদিন
হ্যাঁ
সেটা তো জেনে বিগত 1 মাস
যা গেল
ফিগারটা কিন্তু আপনার আগাগোড়ায় এই ছোট থেকে দেখছি এখানে কোথায় থাকা হয়?
থাকি। সিমেন্টস আছে না, সিমেন্টস
ওই চোখটা
অ্যাক্রোপলিস
এত বলে
ওইখান থেকে সেই অভিষেকের পেছনে রাস্তা দিয়ে তো আসা।
ওখানে আনন্দ দেখায় আনন্দ দিলা সব যায়
আমার কাছাকাছি ছিল স্কুল বিকাশ সঙ্গ আরো আছে, আফেল বাগান টাগান
জায়গায় থাকবে না
আচ্ছা আছে।
হ্যাঁ একদম। মানে সেন্ট্রাল ক্যালকাটার আরেকটা অংশ সেন্ট্রাল যদি এদিকটা হয় ওইটা ওই দিকটা হচ্ছে সেন্ট্রালের
সাউথে
সাউথ সেন্ট্রাল হওয়া এতটাই
কাছে কাছে আছে, কাছাকাছি মধ্যে আছে
কিষান কিষান সব
দিশাটা গুলো তো লাইন দিয়ে
একদম
একদম সে চলে গেলে টিয়ারলেস সব
জানি আমি থাকি তো করি
ওই তো ওই রাস্তা
টিয়ারলেস তো আমার বাড়িতে
তো তা আমাদের কাছ থেকে আর যদি কত সময় লাগে 5-7 মিনিট 10 মিনিট লাগে, মানে ভেহিকেল 5 মিনিট লাগে।
টিয়ারলেস আমাদের বাড়িতে রাস্তা কি আছে আমি টিয়ারলেসে থাকি না স্টেশন
আমরা স্টেশনের কাছে একদম স্টেশন কি আছে
স্টেশন থেকে আমার ফ্ল্যাটের ডিস্টেন্স
আছে, তাহলে ঘুরে আসতো।
একদম আর এদিকে ওই সৈকতটা এখানে শিফট করছি কারণ এখানে নিচে চেম্বারটা আছে
স্টেশনটা খুব ইম্পর্টেন্ট। হ্যাঁ
দাদা
বলো
খবর পাঠাইছি দেখছে অক্ষয় দিদি বলো
হ্যাঁ
অক্ষয় দিদি বলো তারপরে
চলছে এখন পার ডে চলছে পার ডে কিছু একটা বলেছো।
আমার ফ্ল্যাটে পুরিয়া স্টেশনে আমার ফ্ল্যাটে ফার্স্ট ফ্লোরে একটা বড় ফ্ল্যাট দরকার আছে 1300 স্কয়ার
বড়ই হোক
3500 টাকা
300
সাড়ে সাইডে চালা যাবে।
সিঙ্গেল সিঙ্গেল বিল্ডিং না আছে
আমাদের ওই টোটাল 20টা flat হচ্ছে।
সিকিউরিটি কি আছে
হ্যাঁ
সিকিউরিটি আছে
না খেয়ে দেয় না, নিজের ইচ্ছা বেরোবে নিজের ইচ্ছে। হ্যাঁ চাবি সিস্টেম আছে, ভাঙা চাবি।
এই যে ঢুকবে
তবে ফ্ল্যাটটা আপরাইজিং, আপরাইজিং কেন সবাই সিসি পেয়েছে যে গ্যারেজের পোর্শনটা ওইটা একটু জল হতে ওইটা সিলিং করে এগুলো চলছে।
লিফট আছে
হ্যাঁ
আর
কনস্ট্রাকশনটা পুরোনো, কনস্ট্রাকশনটা ভালো, কারণ আমার ক্ষুদিরামের যেটা আছে ওইটাতে তো একটু কিছু মারতে গেলেই তো কষ্ট করে আসে, সেটা একদম ভাঙতে অবস্থা খারাপ হয়ে যায়। এই যে লাইনে এগুলো করানো হচ্ছে কাজগুলো, কংক্রিটটা এত স্ট্রং,
কোনিয়ারে কোনিয়ারে কত
এর
বছর
কনস্ট্রাকশন অনেক আগে, 2008 4-5 স্টার্ট হচ্ছে।
সামনে কত
ক্ষুদিরাম থেকে 10 থেকে 12 নেবে, ক্ষুদিরাম কিছু আসছে হেঁটে 10-12 মিনিট। আর একদম ফ্ল্যাটের সামনে থেকে রিক্সা যাচ্ছে একদম 8টা
Minute, may can't be allowed to mention one matter or one matter method. I'm with service to other sides, you know. This is for the enlistment under the caption hearing, under the caption hearing, you know.
My lord. My lord, application for restoration.
My lord, hearing matter, my
Give all the applications.
May I interconnect?
Take all the applications.
Content application, my lord.
Give all the applications.
lord.
My lord, may I be permitted to mention, my lord, item number 185 of your lordship's today's list, my lord. Friday, my lord, I mentioned the matter, my lord. Your lordship was pleased to give.
Nobody was there. Entire list was called Friday.
No, my lord. What has happened, my lord? I mentioned the matter on Friday, my lord. Your lordship was pleased to give direction upon the, my lord. Your
So what?
officer, my lord.
That was subject to that the matter is not taken up. It was taken up on Friday.
My lord, 27th is the date for.
It was
taking-
taken up on Friday, sir. Ask the court officer, I have indicated that this matter was mentioned. You did not appear.
No, my lord. Your lordship was pleased to give direction upon, my lord, the officer, my lord, to appear the matter as on Monday, my lord. That's why I mentioned.
Hey,
In the list also, my lord, it was appeared.
okay. ঠিক আছে। তো ওটা লিখেছো? তবে তো 135 they did not appear. Just wait. Let us see.
Lordship, may I?
Lordship, may be permitted to mention on matter for upgradation, Lord.
No.
Lordship, after.
Give all the slips. When I have said give all the slips, then why you are mentioning?
Sorry, Lordship.
Sorry, give all the slips. This is give all the slips. Call the list. আজকে মোশনটা ধরবো। মোশন ধরবো। Yes.
I don't want, I am for the petitioner, my lord.
Yes.
My lord, petitioner was appointed on 4th January 1975 as peon before the settlement officer Alipur, my lord. Thereafter, my lord, he got promotion on 4th March 1977. Thereafter, my lord, petitioner got cerebral stroke and he couldn't attend, and my lord, several letters was given to the concerned authority, but no response at all, my lord. Even, my lord, when he was fit, he also filed application before the concerned officer. I have already annexed all the applications, my lord. Subsequently, my lord, on 13th December, my lord, on 17th October 2002, he died. And after death, my lord,
Habitটা চলে গেছে।
petitioner made an application for appointment on compensate ground, my lord, in died in hardness category.
When he died,
My lord, thereafter, my lord,
when he died,
died, my lord,
17th October
17th
2002.
October 2002, my lord,
17th.
October
2002.
2002.
After an absence of about more than 25 years.
Ah, you need not have to. I have gone through the order.
My lord,
Two times true.
yes, my lord, 2002. And I said P5, page 31, my lord.
When he was supposed to retire,
My lord, at the age of 54, he died.
Oh.
Age of 54.
yes.
Thereafter, the petitioner made an application for compensation appointment, my lord, and filed an application before the state.
I have gone through it,
Yes,
sir.
yes, my lord.
Your father did not join service since last 25 years. He was absent. He was under suspension at it says.
My lord,
He was under suspension.
it is my verbally told, my lord, but he didn't get any notice nor.
I do not know, but he
Yes.
was under suspension. So whether suspension was lifted, I do not know. And show us the law that merely because a person could sustain for such a long time, because one of the criteria is the family support, sustenance.
My lord, according to my lord,
Slow kara jayega.
West Bengal service rule,
Was he getting a suspension?
No, no.
Suspension
he
allowance?
didn't get any suspension allowance,
Then
nor he didn't get any death benefit till date, my lord.
true, but
It is legally asked, my lord.
but the difficulty is now what to do. What to do, sir? Tell me, show us the law. We are sympathetic to you. Show us the law. Armed us with certain authorities, we are ready to give you. But you show us the law.
My lord, West Bengal service rule.
I am asking, sir, mere saying will not do. You'll have to show some authorities, some provisions of law, what it says. Tell us. Argue.
And he didn't dismiss from service, my lord.
True. But if there is no immediate financial support required, then in that event, whether the compassionate appointment can be considered in this regard.
My lord,
Because that shows that your income was sufficient enough to cater the entire need of the family. It is merely a financial support to the family. If the family has a sufficient means or the income is sufficient enough to cater the need, does it mean that a compassionate appointment as a matter of rule? Nothing.
1969, volume 3, SEC course.
Show us. We are
But,
waiting, eagerly waiting for those judgments. Show us the authority. You can't argue on a sympathetic or sentimental ground. Law is to be seen. Show us the law. We want. You are not equipped and you are coming and arguing the matter. Then what assistance we expect from the member of the bar? If you do not argue, can we make out a case for you?
Kindly give me 2 days time, my lord. I shall.
2 days time.
shall-
Last weekend you got the time. You said, give me time. We adjourned the matter. Again today when you are coming, give me 2 days time. Then what for you are briefed and why you are coming before the court?
Government order and also, my lord, West Bengal service rule.
Sir, show us.
I-
You are arguing everything in air without any documents being placed before us. Show us. We are ready to hear. We are ready to look at the documents, to see the documents. You are unable to see everything. You are arguing in air.
My lord, kindly make it my 2 days time, my lord. I shall come. Here and,
The learned advocate for the appear does not appear to be ready in the matter. Let this matter go out of list for the time being, liberty to mention
my lord,
the
my lord,
moment the learned advocate feels that he is otherwise ready in the matter.
my lord,
Sorry. Prepare yourself and then come.
Lordship, I'm for the state. Lordship, in this matter, state was directed to verify whether I have made application for trainee reserve or not. Though I have annexed those application in my petition,
What?
trainee reserve, Lordship. Lordship, the order dated 22nd February 2023, the last
But
paragraph.
this was the document which was not filed before the tribunal. You are first time relying on those documents. So we said that you please, the learned advocate for the respondent shows his inability to respond.
Lordship.
So we have to hear him.
Yes, Your Lordship.
Yes, madam, you are for the state.
My lord,
On your ground, the matter was adjourned.
my lord, Choidali Bhattacharya is hearing matter is going on courtroom number 5.
Madam, this was a matter which was especially fixed. She knew about it. Then why?
My lord, the madam, Choidali madam said they give me a short pass over.
What is going on? The first matters are being adjourned.
Lordship, probably.
And we have indicated that we will not grant adjournment in first 25 matters. And look at it, that is absolutely a farcical note.
My lord, they filed the application. Give me a short time. Application filed, already filed.
What filed?
Lordship,
What application already filed? She said, I do not know what application, what she want to say, nothing.
Lordship, kindly consider page 315. It is their admission that I have filed the application for trainee reserve. 315 in the written order.
I'm not going into this. You annex certain new documents for the first time in the writ petition,
Yes, Your
which was not there in the before the tribunal.
Lordship.
So the advocate for the state says that we can't respond on those documents in absence of any instruction because we didn't know this document is coming for the first time.
Lordship.
We adjourned the matter, granted him a liberty or her a liberty to take a instruction. And this is what the instruction comes. Adjournment. Madam is somewhere else.
Lordship,
My lord, I am appearing for the state, Mrs. Choidali versus senior.
You are appearing for respondent number 5 and 6. Miss Choitali Bhattacharya was appearing.
For the state, my lord.
Oh, your name is Kartik Chandra Kapas. Oh, yes, you were appearing for the state with her. What do you have to say? What is your instruction on these documents?
Instruction already filed. And
Instruction already filed, my lord.
yes, Choidali.
What instruction already filed? I do not know. This matter was listed on 20th of March. And you were supposed to take instruction. Thereafter, this matter is listed today.
Another 6.
I do not know. There is only one writ petition and there are 2 affidavit of service. There is no other cause papers in the file. And you say you filed the instructions. I do not know.
You are saying the Mrs.
Yes.
Choidali what says informed.
This is how the state reacts
My
to
lord,
this.
then tomorrow, my lord.
Tomorrow, adjournment. Very easy to get an adjournment.
My lord, I was in.
You are not a privileged litigant, sir.
আপনাদের ইনস্ট্রাকশন আছে কোনো ইনস্ট্রাকশন অ্যাপ্লিকেশন ফাইল করেছি ইনস্ট্রাকশন আছে ডেকে নিয়ে আসি ফোন করো ফোন করো ফোন করো ফোন করো ফোন করো
Sir, the whole country is watching your performance. I have discontinued the live
respondent. Now, well, I think that matter should be relegated to the tribunal in view of a previous order made by
Where is Mr. Pinaki Dhole? Mr. Tapan Mukherjee was here. You are for the respondent. Yes.
In terms of a previous order made by this court in this proceeding, 26 November 2018 order, kindly see. 26 November, I'm sorry.
এটা রাখতে হবে অন্য ওইদিকে রাখতে হবে।
Now this 1688 and
All these things are now over.
Now
Over.
we have disposed of.
By previous order.
Now what is the
The only thing
the
is,
order is very clear.
yes. So
It-
therefore,
it seeks to implement the
an order,
order
non-existent
of
order.
August
Order
16,
which is
2016, which was non-existent.
Non-existent, not recalled, but
So-
non-existent.
No,
not
it
even
was
signed.
non-existent. It was not recalled.
It was not signed.
No.
So non-existent.
Page-
No order,
But
page
in
150
technical term, recalled.
my lord. True, correct. So, my lord, I will be humbly beseeching your lordship, my lord, matter be relegated to the tribunal. Let the tribunal decide the, my lord, OA, my lord, this
page
OA 489 of
150,
2016.
kindly see 150
Well,
last
Mr. Mukherjee need not contest. I am saying that the matter should go back. OA 489 should be heard afresh.
It has to be.
And my lord, today I am, my lord, one judgment of, incidentally, this honorable court, my lord, is against me also. My lord, let me try to persuade,
What?
my lord,
One
a
of my
judgment,
lord have
my lord,
decided that
WPS
work charge
8
charge
of
employee is not entitled to
2022.
be considered for
Work charged employee,
Oh,
that
oh,
compassionate appointment.
yes. If they were drawing the wages as a under the work charge contingent.
Continuous.
Now
That
that
point has been
issue
decided by
has
your
been
lord.
decided. Now, my lord, let me try to persuade the tribunal, my lord, if
To take a contrary view.
not contrary.
Or
Lord, if I can
view
persuade-
contrary to law.
Yeah, there's a factual difference, my lord.
Anyhow,
Person-
go there. It shows
Well, I should be very honest
Which
before
is-
lordship, my lord, even
no,
if
no.
judgment is against me, I should point it out.
which was the impugned order here.
My lord, here the impugned order is
21st February 2018.
21st February 2018.
Was only last page.
Last annexure.
Last document. Certified copy of the order passed by the Learned Tribunal. The order has to be set aside.
The subject matter of
I'm
this,
taking a lot, kindly.
the seminal point involved in the instant writ petition is whether a tribunal can pass a direction upon the authorities to do a certain things in terms of an order which was not signed by the members and impliedly recalled by a subsequent order. By the impugned order, the tribunal directed the respondent number 3, the Joint Secretary, Public Works Department, to take a decision afresh, as the earlier order dated 9 December 2015 passed by the said authority was set aside by an order dated August 16, 2016. This raises the above issue whether the order dated 16th August 2016 is in existence, having not signed by the members, and the direction can be passed upon the authority to act on the basis of such order at the time of an admission of the instant writ petition. The predecessor bench noticed the aforesaid fact, but on the prayer of the respondent, the writ petition was kept alive, as other 2 writ petitions, being WPST 1688 and WPST 1689 of 2008, are pending. This bench had an occasion to consider the aforesaid writ petitions, being WPST 1688-1689 of 2008, and did not find such points to have been involved, and disposed of the same on the basis of the merit involved therein. The instant writ petition was segregated for the simple reasons that the point taken herein is distinct, separate, and different to those writ petitions. So, as indicated above, though the order was passed by the tribunal on August 16, 2016, but the said order was not signed, and on the following date, that is August 17, 2016, the tribunal records that the said order has not been signed and therefore will not be considered to be in existence in eye of law. The factum of non-signing of the said order is further reiterated in a subsequent order dated November 3, 2016, written in the handwriting of one of the members of the tribunal, with clear stipulation that no action to be taken by the authorities to implement the order dated August 16, 2016. Stop. The order becomes final and operative in law the moment it is signed by the tribunal or the court. Now, unless it is signed, signed. The order which has not been signed does not have a legal recognition nor to be implemented. Full stop. There is no quarrel to the proposition that the court or a tribunal passing an order in the open court may recall the said order before it is signed. May recall the order before it is signed. Stop. This appears to be so in the instant case, which would be evident from the letter order dated August 17, 2016. The moment the order has been recalled or remained on paper without having any legal efficacy or binding, cannot be directed to be implemented by the authority by the subsequent order passed by the tribunal. We thus find that the impugned order is invalid, illegal, and cannot sustain in eye of law. Stop. The same is hereby set aside. The matter is remitted to the tribunal for hearing the tribunal application afresh, and endeavor shall be made to dispose of the same on merit by recording proper reasons in accordance with law within 2 months, 3 months from the date of the communication of this order.
Careful.
You have not given us, but there is a special bench judgment of our High Court presided over by Justice Bhaskar Bhattacharya. A point arose whether the court can suo motu recall the order before it is signed. The special bench has held, yes, there is no difficulty. Yes, I have also taken a same view. There is a view of the Supreme Court, if I am not wrong, 88 Supreme Court. Yes. Yes, call the next. Yes, sir.
But I appear for the petitioner, that on the last occasion, your lordship took up this matter and passed an order on which the learned advocate appearing for the state respondents was directed to take instruction. Your lordship kindly have a look to the order passed by your lordship.
Yes. You issued a memo permitting him to join. On the same day, you recalled it. You said you will not be permitted to join. What remained?
For first part is concerned with regard to his lordship's order, my lord, I am very candid before his lordship, my lord. I have no instruction. Now, my lord, second is, my lord, on the last occasion, my lord, the 3rd of September 2021, my lord, twice he has been directed to reinstate, and thereafter on the same day it has been terminated. That has been recorded in the order. Now, my lord, thereafter, my lord, 2 tribunal application has been filed by the petitioner, and both the applications, my lord, the court directed the authority concerned to dispose of in accordance with law. In both the occasion, my lord, they hold no, we will not allow him to join. But whether he will be
Leave him.
whether he will be suspended or not, that is
A different issue.
that-
Leave him.
that
You
is not
can't.
done.
You can't have both.
Now,
You will not accept the resignation letter permitting him to go. You will not permit him to join the duty.
now, my lord, in the meantime, what happened? my
What
lord,
is either take one course. If you do not want him, leave him. If you want him, then let him join.
And proceeding has been initiated.
Now, my lord,
No salary has been paid.
now, my lord, the
No
proceedings,
subsistence
the
allowance, nothing.
proceedings has been initiated. Thereafter, my lord, second show cause notice has been issued. Second show cause notice issued, my
What
lord.
is my salary?
That is, my lord, second show cause notice has been issued.
Suppose then he is still in there. If he is under suspension, you pay him the suspension allowance, sustenance allowance.
This is the fallacy. my lord, the order.
That is
my
the
lord-
officer. Is a fallacy of the officer.
Yes, that's why, my lord, I'm saying, my lord, if his lordship kindly,
You can't treat him like this.
my lord, may I just say, my lord, what is the ultimate finding of the authority concerned, my lord? My lord, may I just, my lord? Now, therefore, after careful consideration of the entire gamut of the situation, it is ordered that the prayer of Dr. Bishwas seeking of withdrawal of resignation and also for permission to resume the duty cannot be accepted.
Then what does it mean?
Festival.
Kindly, what does it mean? Please tell me. A person tendered the resignation.
Lordship.
Either you accept the resignation letter or
you-
you refuse or reject the resignation letter. You will neither accept it nor reject it, but you will not permit him to join duty. I do not find this kind of a stand. This is absolutely a fallacious stand which is taken.
and
Take one decision,
Lordship.
whether you want this man or you do not want this man.
And my lord, lastly, what they hold, my lord,
Yes.
provisions of service rules of the state and conduct being most unbecoming of a public servant and also a member of WBPHS, suitable disciplinary proceedings shall be
Initiate, then
against
put him under suspension, give him a subsistence allowance. He will face he will say that one day one memo says you join, next memo says you do not join. What he will do? Whether he becomes he acquired that particular notion that he is unbecoming of the to continue in the service. What is this?
No, my lord, in the tribunal, my
Sorry,
lord, no, my lord,
we
in the
can't.
tribunal, my lord, may I just read that order one line, my lord? The respondent has taken the right of decision to in initiating a departmental proceeding against him.
The tribunal has fixed the matter for hearing.
Lordship.
But here is a case that what is the necessity? I do not know. We wanted to bring the entire thing to come to an end. So far as the tribunal application, you have decided to initiate a proceeding, continue. If you have put him under, either you have to put him under suspension or you have to permit him to join. Two things you'll have to do. If you say, no, I do not want him to join under suspension, pay him a subsistence allowance.
No, my lord, that is the
Pay him.
reason his lordship on the last occasion.
Pay
But
him.
my lord, most unfortunately, I am very candid with his lordship with regard to this, my lord. I have no instruction in spite of repeated reminders, my lord.
Then what can be done? Can it be
Yes,
can
my
it be
lord.
taken
What
in this
else
regard?
we can do, my lord, unless and until arguing before his lordship on the.
This is not expected from the state.
Absolutely, my lord. And not only that, my lord, in the tribunal, my lord, what has been the submission of the learned advocate that Mr. Banerjee submits that as long as the departmental proceedings are going on, it is the prerogative of the state respondent either to allow or not to allow the applicant to resume his duties. Mr. Banerjee further submits that prayer of the applicant of both the
So
ways are
it's a double jeopardy. He is
That's
not
why, my lord.
paid anything on this.
That's why, my lord.
So how can it be done? It's an unreasonable stand.
And my lord, tribunal has said, my lord, that both the
Stop.
benches not sitting, my lord. We have fixed this matter on 24th of July. And in the meantime, what happened is, my lord, in the 2022, my lord, the second show cause notice has been issued. And he has
True, there is no difficulty. It is within your rights to initiate a disciplinary proceeding. They can't come and say that you can't initiate. They can. But you continue, but you'll have to take two decisions, either to permit him to join or you put him under suspension, pay the subsistence allowance. You can't adopt a third method.
There is no.
So
No, this is the no, my lord, I am whatever I
right.
have tried my level best to, but what has fallen from his lordship.
what do you want to join?
Yes.
Join.
Yes. That I have last received my salary. I have last received my salary in the month of April, for the month of April 2021.
Last salary paid.
শুনছে মুই 30 তো বলছি এই ক্যান জয়েন চিকেন সুপার যদি দাবা বলছি হ্যাঁ তাও পাবেন এই দেখো না 21/10 দিয়েছে 21/10 পর রিপ্লাই রিপ্লাইও দিয়ে দিয়েছে প্রশ্নটি হচ্ছে ডিসমিস এই যে now furthermore is to submit within 10 days is for the
And I am not receiving any salary from the month of May 2021. And
now my lord
I have,
Wait for the order to come.
I'll leave it up.
now my lord I was told by learned AGP that since Millard's second show cause notice has been issued and he has given a reply now thereafter in paragraph 15 also they have said Millard that the second show cause notice has been issued so there is an every possibility Millard that he will be dismissal from the service so that's why it is his prayer kindly see paragraph 15 kindly see paragraph 15 may I read Millard your prisoner states that
Sir, Mr. Basu Mundi, as on today, there is neither a dismissal
nothing
nor termination.
nothing
Matter ends as on today. What we want to say is this. But otherwise, you take your step, take
now, Millard,
whatever.
in paragraphs I
You
just
can't contemplate
No,
that
I am-
there will be a order of dismissal.
no I am not contemplating it is there
Their apprehension is always there because the moment the disciplinary proceeding is initiated, they always think the major penalty would be imposed.
first things is gone Millard now the second show cause notice issued he has given.
I know it. I understand it, but the reality is till today he is neither under suspension nor he has been allowed to resume duty.
Now, Millard, so far both these
What more?
in both these occasions Millard it appears Millard they have not allowed him to join
So that's thank you. Yes, call the next.
In this matter. Here, my lord, against the refusal of pass an interim order before your lordship. Disciplinary proceeding started in January.
Just wait. Refusal to pass interim order or passed interim order.
My lord, entry prayer was, my lord, initially the disciplinary
Just I am asking you, refusal to pass or pass the interim order?
refusal to pass.
1 second.
Even the prayer has not been touched.
Just wait.
Lordship.
What is the nature of the interim order?
My lord,
Which you prayed for?
Lord,
Which
that-
page?
I'm telling my lordship. My that is at page 117. 117. 117. Lord, praying for stay of the
Just wait.
That order cannot be stayed. In my respectful submission.
Where is the interim release?
Hundred and 16.
Page 116 is my
No, no, what modification was sought? I was really
Lordship.
wondering. I say I have seen
modifications, but
the learned
2014.
counsel for the applicant prays for liberty to modify the prayer A in the relief portion.
Well,
What
modify means
modification?
one word has been omitted, that has not
What
been
is, that is withdraw and or cancel.
withdraw and or cancel. There was a typographical error that has not been inserted.
Why they have not paid it?
I don't know, my lord. That is the reason I am before your lordship. But
No, no, no.
initially the
There
disciplinary
must be
posting,
some communication,
Yes, what are the final order? is
just communication.
after passing this order, no such communication. But after passing this order, I am entitled to get the pension and everything. That has also not
No,
been
no,
discussed.
no. There is a proceeding initiated for imposing a penalty.
Lordship, I am paying stay of that order and my lord, disbursement of my pension, gratuity and other pensionary benefits.
Under the law, I think there is a provisions which can withhold the
My lord, law
gratuity.
says, Rule 10(2) says, my lord, after continuation of this disciplinary proceedings, I am entitled to get the provisional pensions. Now,
So you are only entitled to provisional pension.
provisional pension, I have only get the provisional pension. My gratuity or other retirement benefits has not been disbursed.
This will not. You are getting a provisional pension?
No, now I am not getting anything.
No.
After the last day,
Show us the law, Mr. Additional Government Pleader. Show us the law,
10-1.
please. So show us sub rule 12 or rule 10 of the West Bengal Service Classification, Control and Appeal Rules. 2 or 12.
Now, because he has retired, Rule 10(1) would be applicable. Because he has retired from service, that's why his pension has been forfeited. That is other law, under Rule 10(1). Permitted under the law. 100% can be done. Forfeited.
If not instituted, separate, shall not instituted, save with the sanction of the law, shall not restrict the right event takes place, charge to the right of the District not instituted, where the department is instituted, submit one. Evidence. Clause E. So, A. Of the professor against an officer, we shall be paid from the date of the a provisional pension not exceeding the maximum pension. But no consumer such as every day Yes, was it initiated during his service?
Yeah.
2 months before my.
And then he retired.
Then
In
in 2014, that was
We
initiated,
have got the power to forfeit.
but madam, I'm entitled to get my gratuity amount.
Or no, not. Rule is very clear. It says where any departmental, I am reading for you, where any departmental or a judicial proceeding is instituted under sub rule 1, or where the departmental proceeding is continued under clause A, that is where it is initiated but you retired in the meantime, of the proviso against an officer who has retired on attaining the age of compulsory retirement or otherwise. He shall be paid during the period commencing from the date of his retirement to the date on which, upon conclusion of such proceeding, final orders are passed. What is entitled? A provisional pension not exceeding the maximum pension which would have been admissible on the basis of his qualifying service up to the date of the retirement. Or if he is under suspension on the date of the retirement up to the date immediately preceding the date on which he was placed under suspension. But no gratuity of a death cum retiral gratuity shall be paid to him until the conclusion of such proceeding and the issue of the final order thereof.
Madam, the proceedings has already been concluded. Final
No,
order
it
has
is
been
not.
issued.
Final order has been passed.
Lordship, the final order has been.
Where? That is not here. I do not find rescind.
Kindly come
every-
to page 94.
What?
Page 94.
No, 94 is calling upon to submit within 15 days from the date this
No, but
notice.
90, that is the,
What-
my lord, annexure P8, that is the second so cause notice. Thereafter, my lord, annexure P9 is the, my lord, final order.
95.
95.
Because this order appeal before the appellate authority.
He is a group A officer.
So the imposition is pension
20% deduction of pension for.
for 5 years. That is there under sub rule 1. Governor has a power.
My lord,
So specified date.
I have challenged this. There is no difficulty. My only part is, my lord.
But the
as
gratuity
the
has to be paid
concluded,
now.
I am entitled to get, my lord, the gratuity
He is entitled.
and other pensionary benefits. which
Under
has
the
also
rules
been
also.
discussed.
Under the rules, he is entitled. You can't do it.
And my lord, my second point is, madam,
But no gratuity until the conclusion of such proceedings. And the issue of the final order. Now, final order has been passed. Your provision says no gratuity shall be paid until the conclusion of such proceeding and the final order is passed thereon. So you have already passed a final order deducting 20% of his pension for a period of 5 years. So that is there. So gratuity now you have to pay.
gratuity, commutation, leave salary, all the things are there.
Maybe the payable. What about the outstanding dues that will be paid?
Has to be paid now in view of this rule.
And my lord, second thing is which I am praying, my lord, that is the stay of the operation of this order till disposal of this original application. If they start the deduction, then my lord,
No.
Has to be done. There is
But the
no
discipline-
strong prima facie case that has
but
been
that
made.
I can show
No,
because the documents has
No.
not been supplied to me.
that is
One
a different,
criminal
let the
case-
tribunal decide. Let them get an opportunity to do that. 20% subject to the result of this.
One
That's all.
criminal case they have initiated, there I have exonerated, that point they have not taken into
Whatever.
consideration. And one more thing, my lord, from the date of retirement till the date of final order, I am entitled to now get the pension after deducting the amount which they have paid already as a
No,
provisional
no,
pension.
that is what is a provisional pension.
Lordship.
And they have said
Kindly see, my
prospectively.
lord, clause 3 of the rule 10.
Now, when you retired,
I retired on my lord 31st March 2014.
14.
14.
So 5 years has gone,
5 years has already been gone.
but you were paid the full pension. No.
Nothing has been paid. Only the provisional pension which has been stopped after the order of final order, after the final order. And now I'm not getting.
And what is the
anything.
provisional pension? It is less than 20%. Or
50%. 50% of the pension.
50% of the total pension is paid as provisional pension.
Last basic pay, 50% of it. Last
Oh,
year,
I understand. That is a pension. I understand. I am asking you, in 2014, he retired. He was getting a provisional pension because the disciplinary proceeding was continuing. What is the quantum of this provisional pension? Is it a 50% of the pension admissible to him? Or it is a 60% of the pension admissible to him? Or it is a 80% of the pension admissible to him? Because the rule says not exceeding the full pension. So it must be below. I was thinking in the light, if he's paid 20% less the pension which is admissible,
he was getting 50% of his pension.
so 50% was withheld by you.
Yes.
So you are supposed to pay the 30% of more because you paid him less. So 20% was deducted. So they have not
No,
indicated.
that order was passed when final order was passed.
Ah. I'm asking you a very simple question, sir. If his contention is correct that he retired in 2014, I'm asking you a very simple question. Please, because the final order does not say from which date it will.
That has not been indicated.
I'm coming to that. So if in 2014 he retires, disciplinary proceeding was continuing, no doubt. He was paid a provisional pension or not? Till paid. Then how much provisional pension you determined? Obviously not the full pension.
No.
Must be less. How much less? If you paid the 50% of the pension which is entitled, that means you withheld 50%. Final order says 20%. And from 2014, if it is deducted, then in 2019 that is over. From 2019 is entitled to full pension. And if you have paid less, then is entitled to this 30% more. Because you can withhold only 20%. So 30% you have to pay because you paid only 50%. So he's entitled to 80% of the pension. Am I correct? Now I'm again. I know you say that you came from a village, so that's why. Now you are supposed to pay him 80% of the pension. 20% you will deduct, correct? But you paid 50% only. So will you not pay 30% more? And if it is to reckon from the date when he retired, then 5 years has gone. We will indicate it. 5 years has gone. Then from 2019 he is entitled to full pension.
But our final order was passed on 5th of May 2022.
22.
5th of May.
True, no doubt. Do not make it a prospective. Then you will have to pay the full.
On the date of retirement, till 5 years.
Correct.
Five,
So that has to be given a retrospective effect.
from the date
So
of
for
retirement.
2019 gone, 5 years completed. Then he is entitled to full pension. And then he is entitled to a gratuity from the date of the order.
Now the passing of the final order. 5th of May 2022.
Pay him. How soon?
Within 3 months, Malan. Within 3 months. Well, a
Pay him
calculation has
1
to
month.
be
We
made.
are coming. We will
We should have to-
dictating.
we should have to send it to the AG Bengal. Because
AG Bengal is outside the domain of the government. State government.
They are central government, but they are under the Control General, Auditor General of India. But they are under the central government because they will file a report before the parliament.
But they hold the corpus of the state as well.
No, but they will calculate and check the amount, then will release.
No difficulty, sir. You release it. Everything has to be done.
No, let them verify and check it, nothing more.
We are directing every entire thing to be done within 1 month.
Now only but kindly
We are coming back. We are not going too technical that at the interim stage what the court should pass. Once we find that it is a legal right,
আমরা ভাবছিলাম retrospective
এইটা তো
Come.
But give me some time, but because we shall have to forward the papers to the AG Bengal. Malad,
The court, assailing the final order passed in a disciplinary proceeding on 5/5/2022, the tribunal was approached with OA 586 of 2022. And an interim order was sought therein that pending the said tribunal application, the operation of the final order should remain suspended, and the respondent authorities may be directed to disburse the pension along with the retirement benefit, including interests. Indubitably, the disciplinary proceeding was initiated against the petitioner while in service and continued even after attaining the retirement. Sorry, attaining the age of retirement. So far as the final relief claimed in the tribunal application is concerned, the same shall be decided after affording an opportunity to the state respondent to file affidavits, to which we do not intend to make any observations thereupon at the interim stage. Though the impugned order does not contain any observations relating to refusal to pass an interim order, but the tenet thereof unequivocally suggests that the prayer for interim order has been refused impliedly. The tribunal application is fixed for hearing on 10/7/2023. And we expect that the tribunal would take up the said application on the said date and decide the dispute on its merit. We noticed from the final order dated 24/9/2029, 24/9/2019, that the governor has been pleased. Sorry, 24/9, no, 5/5/2022, 5/5/2022, 5/5/2022, that the governor, in consultation with the Public Service Commission, West Bengal, has inflicted the penalty of, within court, pension cut of 20% for 5 years upon the petitioner in terms of Rule 10 within bracket 1 of the West Bengal Services within bracket death cum retirement benefit bracket close rules 1971. our attention is drawn to Rule 10 of the said rules, which runs thus. Quote করে দাও। Upon a meaningful reading of the aforesaid provision, which according to the learned additional government pleader as well as the learned advocate appearing for the petitioner are applicable, we find, we find that sub-rule 1 empowers the governor the right of withholding or withdrawing a pension or any part thereof, whether permanently or for a specified period, together with the right to recover from pension the whole or a part of the pecuniary loss caused to the government, provided the delinquent is found in the departmental or a judicial proceedings guilty of grave misconduct or negligence during the period of his service. We does not find any fetter on the part of the governor to withhold the pension or the pension or withdrawing the pension or any part thereof. Permanently or for a specified period, which in fact has been exercised in the instant case. By final order dated 5/5/2022, the governor has been pleased to withheld the pension up to 20%, withheld the pension to the extent of 20% of the pension admissible to the petitioner on attaining superannuation for a period of 5 years. But we do not find from the set final order as to when such order would take effect. It can be logically inferred that the said penalty by withholding 20% of the pension admissible to the petitioner should reckon from the date of the superannuation, as the right to receive pensions fructified from the said date. Sub-rule 2 of Rule 10 of the said rules postulates that where a departmental proceeding is continued even after attainment of superannuation by the delinquent until the final order is passed, a provisional pension not exceeding the maximum pension as admissible on the basis of a qualifying service up to the date of the retirement shall be paid to such employee, with further stipulation that no gratuity of death cum retirement gratuity shall be paid to such delinquent until the conclusion of the said proceeding and the issuance of the final order thereon. Naturally, the moment the statutory provisions puts an embargo on disbursement of the gratuity on death cum retire, gratuity of the death cum retiral gratuity till the departmental proceeding culminated into a final order, comma, there is no obligation on the part of the government to pay the same. Stop. The fact remains that the final order has been passed on 5/5/2022, which is a subject matter of challenge before the tribunal. Stop. So long the said order remained in operation, comma, the delinquent cannot seek any relief as interim measure to suspend the operation of the said order unless a very strong prima facie case is made out. We do not feel that the interim order of such nature can be passed at this stage, suspending or staying the operation of the final order, which would be decided the final order as the legality and the validity of the said final order shall be decided at the time of final disposal of the writ petition. However, we cannot countenance to the proposition that pending final decision taken in the writ petition, no amount by way of gratuity or the pension should be paid to the petitioner, as it would run contrary to the spirit and the object of sub-rule 2 of rule 10 of the said rules. The said sub-rule provides that the moment the final order is passed, the gratuity would be immediately payable, depending upon the nature of the order to be nature of the order, nature of the final order, which in this case does not appear to have put any absolute fetter on the part of the authorities to deny the disbursement of a gratuity. Stop. Furthermore, the final order reveals that the pension was withheld to the extent of 20% of the admissible pension for a period of 5 years. And therefore, it cannot be said that any major penalty has been imposed upon the petitioner. So, it is undisputed that the petitioner was paid a provisional pension under the aforesaid provision, which according to the learned Advocate General was 50% of the admissible pension in the event no disciplinary or a judicial proceeding is pending against the employee, which according to the petitioner has been withheld and or suspended since the month of
March, 31st March, I have retired, 31st March 2014.
no provisional pension has been withheld.
Provisional pension has been paid.
Is still being paid.
No, that has been stopped.
When?
May 2022.
Since May to 2022.
Lordship.
We do not find any reason for withholding the provisional pension when the final order does not indicate so. The moment the authority have inflicted the punishment, withholding 20% of the admissible pension for a period of 5 years, comma, it cannot withhold the provisional pension, which was in fact paid up to the month of April 2022. Stop. We have indicated that the final order does not reveal the operation thereof from a date. It is logically inferred that such withholding of the pension would be from the date immediately after attainment of superannuation. And in this case, the petitioner retired with effect from
31st March 2024.
31st March 2014.
2014.
Since the 5 years period expires, on 31st of March 2019, we do not find any justification in not paying the full pension thereafter. Full stop. The law as it stands does not give unbridled right into the employer to do certain things which is in conflict with the set statutory provisions, nor can travel beyond the circumference thereof. Stop. There is no justification in adopting such approach by the authority, and therefore, the moment the right is crystallized from the aforesaid statutory provision, such right cannot be defeated at the behest of the executives. Full stop. We therefore therefore direct the respondent authorities to pay the difference of the pension after deducting the percentage of pensions as indicated in the final order dated 5/5/2020, together with the gratuity of the death cum retirement gratuity admissible to the petitioner on the post which he lastly held within 2 months from the date of the communication of this order. We expect that the authorities would take all possible steps in order to adhere the time limit indicated herein above, and all authorities who have a role to play in this regard are supposed to show alacrity in discharging their respective duties in this regard. since the next part, since the writ petition, since the tribunal application is pending, where the final order is assailed by the petitioner, none of the observations made here in above shall have any persuasive impact thereupon. Full stop. With these observations, writ petition is disposed of. No order as to cause.
Only one thing, with the gratuity, they have to disburse the other retirement benefits, because except provident fund, nothing has been disbursed.
Gratuity as well as other retirement benefits.
I'm grateful.
Hey, he will quote that provision of Rule 10. Tell your junior to
Take up. ওটা দেন তো আমাকে।
ওখানে word use করা আছে। As well as other retirement benefits.
I'm grateful.
Do one thing. Do one thing. Sono. তোমরা দুজন। After quoting that provision, please keep this particular rule here on the DAS, because frequently these rules are relied upon. We are keeping one copy.
Give me 1 day time, I'll make 2 Xerox copies and hand over to Maharaj.
No, we are keeping it. That's a photocopy. We are keeping it. Give one more copy.
Yes.
In course of this day or tomorrow, whatever. Let's call the next.
Kindly take up item number 72 first. No, can it be item number 72 be taken up first?
The 72 and 70, both are same and identical. If your lordship takes up 70
Kindly get it.
Tell me when any document you want to rely, anything in this regard you want to rely.
Lord, I want to file an opposition to this writ petition. No, in respect of item 70, nothing was used.
Nothing was used.
No affidavit was exchanged. Before the
Did
tribunal,
not file.
in 72 affidavits were filed.
We are in 70.
Yes.
Tell me in 70
Same
whether
matter.
they filed the opposition or not.
No.
They did not file. Whether 70 and 72 were taken up together
Yes.
Yes, yes.
by a common order or different order.
No.
Order is covered by 70.
72's order covered by 70.
But in 70, you did not file any opposition.
No.
So for the first time, you are making a lot of statements. They have a right to controvert those statements because you did not state those in the trial court, in the tribunal.
But 72.
Sorry. The present writ petition. No, the present writ petition is filed assigning a order dated 11/4/2022 passed by the West Bengal Administrative Tribunal in OA 674 of 2021, by which the order of transfer was quashed and set aside solely on the ground that a delegatee is not empowered to delegate his powers. Stop. The learned additional government pleader prays for the stay of the operation of the impugned order pending the disposal of the writ petition. Stop. According to the learned advocate for the petitioner, the respondent, that an interim order suspending the operation of the order of transfer was passed by the tribunal, which remained operative till the final order is passed. We thus do not find any ground for staying the operation of this order, as it would result into a direct prejudice to the respondents. More particularly, when the submission is advanced by the learned advocate, additional government pleader, that the interim order passed during the currency of the tribunal application merged with the final order. The interim order is thus refused at this stage. However, we find that the tribunal application was decided without inviting an affidavits from the state respondents. Stop. Since the facts have been pleaded by the state in the instant writ petition, which were not before the tribunal, an opportunity must be given to the respondent to deal with it. Accordingly, the respondents are directed to file affidavit in opposition
By 3 weeks.
within 3 weeks from date. Reply, if any, shall be filed within a week thereafter. The writ petition is returnable 4 weeks hence as adjourned motion. Call the next.
72, 70 and 72 were the same order.
71,
72, same order.
71.
72.
I know it, but in between 71 is there. Let us call that.
I appear for the 71.
Let us call.
71 এর ফাইলটা কোথায়? ফাইলটা কোথায়? ফাইলটা কোথায়?
Which order is under challenge, sir?
For the state authorities, my lord.
14th March 2023.
Yes, ma'am.
Yes.
Who is for the writ petitioner?
I appear.
You are for the
for the
respondent,
state.
state respondent?
Yes, my lord.
Just give us 1 minute time to go through this. Recruitment for the post of a lady constables or constables?
Both.
Both.
আমাদের কোথাও লিস্ট থেকে কোয়ালিফাই করেছে।
One ground is the premature. So far as another ground is concerned, prima facie we are with you. That if the tribunal found that those are a necessary party, then even it can exercise a suo motu power directing you to add, or you could have been given a leave to add. But so far as a premature is concerned, tell us what to do.
My lord,
What is the
I
stand?
have given a list of candidates.
Correct.
Who does not belong-
You derived a notion from the surname.
And my lord, there is
And
I have
then-
annexed the
then
order
it
of
says that merely surname does not indicate that they do not belong to a particular category. If there is a certificate which is appended, then in that event, you have to approach a authority who issued that certificate, challenging it. And then if they do something, then you can come and, which is also the mandate of the Administrative Tribunal Act as well, that you will have to exhaust all the remedies and then approach.
Now, these are the procedural difficulties, my lord. If it is a kindly turn to page 93 once. Page 93.
We will not go by the surname, sir. Mere surname does not mean that.
If these are undisputed.
Undisputed means have they admitted anywhere
Yes.
in the opposition?
Yes. My kindly takes up
They
page 9.
admitted in the opposition.
No opposition is filed. my lord.
Then why you say admitted position?
Page 93, my lord.
Why you say admitted
Because
position?
my state has made it stand clear in other proceedings.
That is not that may be used as an evidence in that. But
Like,
it does not mean
here, my lord, no scope was given for filing
Sorry.
affidavit, my lord. Page 93, my lord, the Honorable Division Bench,
Sorry.
order, my lord. Land Council for the State on instruction has submitted that Kurmi, Kudmi, Mahato are not scheduled tribe, but OBCB. But I have annexed the list of the state of OBCB, my lord. Where, my lord, the Mahato is there. My lord, now, my lord, kindly take some, my lord. OBCB at page 61 of the state.
yes.
Page 61, my lord. Let's clause 26, my lord. Serial number 26. Kurmi Mahato, my lord. Now, my lord, kindly turns to, my lord, page 58.
Yes.
Now, kindly see at least from the top, my lord, 1, 2, 3, 4, 5, 6. Shourab Mahato, Babon Mahato, Mongol Mahato.
Yes.
But these Mahatos names are appearing and let they have,
How do you say that these Mahatos are the Kurmi?
let
That is a surname. Somebody may. There are many surnames like a Sarma. Sharma is sometimes used by some Brahmins. The Sharma is used by some other person. It all depends upon whether they belong to a particular community or a caste. There are certain surnames which is absolutely common in various castes. How can you take it
Let's-
only from the surname? Only the thing is whether the certificate is issued saying them whether they come under the OBCB or come under the SC or come under the ST. If you have a doubts that they do not come, then you'll have to approach the authority.
let the large number of candidates whose particulars I do not know. I do not know in which district they belong.
There was a direction for an inquiry. That inquiry has been conducted.
No,
Then
Blood, all that I pray today, blood, kindly direct the authority, the OBC, other backward class department to file a report disclosing that whether this person can at all be belong to this category or not.
you'll have to approach the authority raising all these points. Then what is the necessity of this
Blood-
section to be incorporated in the Administrative Tribunal Act?
Blood, in terms of the blood notification for 2015, I have annexed, my lad.
এত দূর চলে গেছে
Blood, to whom I shall approach, my lad. That they are belong to different district, my lad. I do not know their district.
Is it a good ground to dispense with?
My lad, otherwise, my lad, these illegalities will continue, my lad.
No,
But this is not a stray incident, my lad. And my lad, I
I
tell you, my lad,
understand it's a serious thing which you have raised, but there is a law and the law is also to be respected. You can't defy the law and jump to something. I understand. Apparently you may have good, but the law is there.
but the procedure has been prescribed under the law.
Correct.
That is
So-
procedure. The law says,
And then I'm again saying, if there is a substantive provisions relating to procedures, then we'll have to be rendered cautious.
that we are before the writ court.
The
and-
writ court will do anything. I have delivered 2 judgments where I have said the plenary power means what?
I tell you, Lordship, lad,
I have declared 2 judgments where I have indicated that what are the powers of the writ court under Article 226. And a plenary power to be exercised, not to be confused with something that the writ court will ignore all the statutory provisions and can do anything. I am very critical of this.
I don't say so, my lad. Whatever,
So if there is a statutory provision which really says
which
that a
does
certain
not,
thing-
lad, which does not, lad, provide, helps me, lad, to combat this situation because I do not know the particulars of these candidates.
but you'll have to
How can I?
approach.
How can
You'll
I,
have to
lad?
approach.
To whom I shall approach, lad?
That is what the court will advise you,
No,
that you will come.
that's the difficulty, lad.
Is it a court or the tribunal who will advise you that these are the
I am not
authorities?
saying, I'm saying the difficulties I have, that I cannot approach any authority.
For that, you will approach the court that you do not know.
That from the
You could get that particular list. You could not get that who is the authority to declare this.
that act, the authority.
Who is the authority
Subdivision-
to issue a certificate relating
Subdivision
to
officer.
scheduled tribe or a scheduled caste?
Subdivisional officer of the respective
So-
district.
So you
That
can
That I do not
can-
know the particulars
particulars
of
of
this.
this.
No,
Can you not raise? That's again an advisory jurisdiction which the court exercise. You can approach
To whom?
some authority. That I can't.
that's
That I can't say.
I do not
I know you can move to whom.
Yeah.
Will I advise you to whom?
No. I'm not seeking an advice, lad.
So
May
I know to whom.
lad, may I clarify my position, lad?
I know to whom.
Lad, the
can.
statute says subdivisional officer. Lad, statute says subdivisional officer, but who is subdivisional officer? Issued certificate in respect of candidate number 1.
আমরা advice করব.
No, I'm not seeking advice, lad.
But we are not accepting this because we know that whom you can approach.
I have to approach subdivisional officer.
That we can't say,
No, that is a statute.
that we can't say,
That is a statute.
that we can't say.
No, that is a statute.
Yes, that we can't say.
No.
That would, in this case, it is a proper approach.
No.
There is a proper approach to some authorities.
May I?
There is a proper
Right,
approach.
statute.
If you are skeptical, if you are in dilemma, whom there are many subdivisional.
No, I have not, I do not have any dilemma.
I'm saying what you say is that there are many subdivisional officers
Right.
in every district. I do not know from which district they obtained the certificate.
Right.
And it's not that we do not understand, but we know how to overcome this situation. Which authority can approach?
Then I have to apply under RTI in respect of every candidate, and thereafter I have to
That's
get.
your understanding. We can't help you out. That's your understanding.
When I am before the court, and from the record and
So
the
that's why you are really making a court and investigating authorities, and then everything to
No.
be done,
No.
create an evidence in your favor, gather an evidence for you.
I am not seeking for that.
This is what you
From the order of division
cannot
bench.
be achieved directly. You are trying to achieve indirectly.
Not-
What is the aim? You say that these surnames indicates that they do not belong to scheduled caste.
That state has said.
Please, this is not a state. A state does not say so.
Yes, ma'am.
Why you say you perceive that look, Kurmi is included in OBCB. Whether this particular surname relates to a Kurmi caste is a first question. There are various surnames which relates to a several castes. You can't jump to a conclusion that it is only restricted to a Kurmi caste on the basis of a surname. There may be an acquired surname. There are many. And I can give you an example, a recent example of our state as well.
May I submit?
We are on live. That's the whole problem. Otherwise, we'd have said that
May I?
many instances.
That may be.
Anyhow.
May I submit? The division bench order at least.
Please go.
The division bench order at least demonstrates
It's
that
premature. Your right has not been
that this
taken
is a
away.
selection process. They're going to be appointed.
Sir,
and
if there is a glaring illegality, do you think that the appointment would create an inchoate right or indefensible right or absolutely or a right which is an absolute one, cannot be touched at all? I don't
Supreme
think so.
Court in recent time had not dealt with this issue. I have brought those judgment. And my
Understand?
Supreme Court says where the Constitution has given certain provisions for a particular community, and that is being
We accept this proposition. The first and foremost answer which has to be found, whether these persons belong to a particular community. If it is found that they belong to this community, then you are perfectly justified in saying that they cannot be converted into another community. The first answer is to be gathered. And where is the situation to arrive at the first answer?
the first answer is given by the Honorable Division Bench.
What? That these
Mahato do not belong to.
Correct. Mahato straightaway says that whoever is using the word Mahato.
That's the order of the High Division Bench.
Show us that the Mahatos are always considered to be Kurmi.
Yes, my lord.
Show us.
Mahato, rather, my lord, Kurmi.
Show us, sir.
The first line says.
Yes, it is merely a repository, nothing more than that. The allegation has been made.
Page
And
93,
then, please read. I have read that order of the then Chief Justice of this court.
On instruction, state submitting that Kurmi, Kudmi, and Mahato,
Yes.
they are equivalent to each other,
Yes.
are not scheduled tribes.
Yes.
What more they can say? They say Kurmi are not scheduled tribe, Kudmi are not scheduled tribe, Mahato are not scheduled tribe. And this has not been challenged by anybody till date. what more milad we can gather. Milad, and milad, this is not a stray incident, milad. So far, when school service commission is concerned, milad, there are a large number of that's the this high court has taken cognizance, milad, and milad cancelled the appointment of a candidate. Now, milad, we have milad gathered milad after filing of this petition, milad, information. Well, milad, larger number of candidates obtain certificates from West Bengal, milad, has cancelled, milad. Milad, that's why, milad, to sort out the issue, milad, if you kindly directs the backward class department to file a report, that they have all information, milad, that whether they are scheduled tribe or not, that would be, milad, enough.
The instant writ petition has been filed assailing the final order passed by the West Bengal Administrative Tribunal on 14/3/2023, holding that the application is premature. It is contended by the learned advocate for the petitioner that in another writ petition being in a public interest litigation being WPA within bracket P 236 of 2021, the state has disclosed his stand to the effect that the Kurmi/Kudmi/Mahatos are not scheduled tribe, but they are OBC within bracket B. Though the aforesaid submissions have been recorded in the said order. No, sorry, on the basis of the aforesaid submissions recorded in the said order, it further revealed from the said order that the state disclosed that an inquiry is in progress in order to find out whether any forced caste certificate has been submitted. And it is expected that such inquiry would be concluded within a short time. We do not find from this, it is categorical from the stand of the petitioner that there is a complete illegality, or there is a gross illegality committed by the authorities in selecting the person for the purpose of recruitment in a particular category. And it is nearly impossible for the petitioner to gather the information in respect of a respective candidates. So, since the inquiry is in progress and the public interest litigation is pending before this court, we feel that the point involved in this may be conveniently determined along with the public interest litigation. Stop. Let this writ petition be placed before the Honorable Chief Justice and be taken up along with WPA.
My lord, may I just indicate one thing, my lord? May I just indicate one thing?
If there is a wrong submission, if there is a right submission, go there and then
Only one
make
thing,
the
my lord.
submission.
My lord, it is
We
premature
can't-
because in the rule, it is already there. Well, there's a provision for police verification, which is all there in the
Let
rules
them-
itself. So
You
it is
have said
premature.
that the inquiry is in progress relating to false certificates. Let it,
That-
we
that
go there,
is-
let him
that is in
satisfy in the
regard with-
PIL, it will
That
be
is
decided
in
there.
regard with one
Yes.
caste. There are other castes as well, which is not there.
True, it is not required because it says that false certificate, caste certificate The matter is pending before the Chief Justice. Let it also be decided there.
And in
let
the
him
service
decide.
rule, there is a provision for police verification.
I
So it
do
would be
not
decided
know.
within
I
the
do
authority.
not know. We'll go before that.
Very well, my lord. Grateful to your lordship.
We do not want to. Yes, call the next. 72.
Yes. Same order may be passed.
No, similar cannot be passed because in that we have said that you did not get an opportunity to file opposition. And that's why your statement has to be dealt with. In this case, we have to find whether there was an opportunity given to him to file affidavits, given to the state to file affidavits. It was filed.
Yes.
So it can't be the same. Point may be the same.
Point is same.
That's
Point
the
is same.
দেখো item number 70 টা যেটা আছে না ওই নম্বরটা নিয়ে নাও। By the impugned order, the memo dated 26 July 2021 relating to serial number 2021 relating to the applicant of the said tribunal being the respondent herein was quashed and set aside on a principle of law that the delegatee cannot delegate his power. On the basis of on the basis of the impugned judgment, another tribunal application being OA, that is there in item number 70, were disposed of, and the said order is assailed by the state in WPCT ST item number 72 করে দাও, such and such. So, since the said writ petition has been directed to be listed as adjourned motion after 4 weeks, we feel that this matter should also be taken analogously with the said item number 70 on the returnable date. Accordingly, let this matter be listed along with WPST.
Extremely urgent matter. This is the matter I moved on the other day, the arbitration. The arbitration matter which I, now after my lord's order, they have locked the premises and my lord, we can't enter or my lord go out of the, we are under
That
house
we don't know. That we don't know.
completely under house arrest. I have amended my my lord application, I have added a bread. Kindly, my lord, your lordship, it's not, they've received it also.
We don't know. We have already passed an order.
Sir, my lord, kindly take step. Because
we
I'm under
can't.
house arrest.
Can't say anything. You have to take out. এটা applet side না original side?
Original side.
FA.
My lord, under compelling
হ্যাঁ ঠিক আছে। ফাইলটা দাও।
For judgment.
Yes, we have modified the degree, granting an interest at the rate of 6% per annum on the decretal amount. And we have directed this amount to be paid to the appellant. Yes,
again, my lord, I am mentioning, my lord, under compelling circumstances. Last Friday matter has not appeared, my lord, in the list, my lord.
yes, call.
আমাদেরটাই তো। আমাদেরটাই। আমাদেরটাই।
আমরা তো বলবি।
হ্যাঁ।
হ্যাঁ, the weatherটা চেঞ্জ হয়েছে। Yes,
My lord, I had the privilege to, my lord, discuss this matter with my senior, Mr. Bhattacharya, my lord. The only thing that, my lord, came to our mind is that, my lord, the 39 Act, if your lordship may kindly considers, whether the 39 Act will be regarded or treated as an exception to section 2 of the 37 Act. Whether the 39 Act, the grounds mentioned therein, my lord, would be considered as an exception to, my lord, section 2 of the 37 Act. That is, my lord, we discussed, if your lordships may kindly considers, because, my lord, 39 Act was a subsequent act, my lord. The framers of the act at that point of time, my lord, were well aware about the 37, the section 2 of the 37 Act. So, my lord, consciously the 39 Act was, my lord, formulated, my lord, only in order to consolidate and to clarify the existing provision of section 5 of the 37 Act. 37 Act, my lord, provided for dissolution of Muslim marriages through court. So, my lord, section 5 in the 37 Act itself was an exception to section 2. Section 2 said, my lord, personal laws will apply.
because we were given what was originally the section or the language used in section 5 of the 37 Act.
My lord, only the
We have not been given, we have not been provided with that. That's the whole problem. Neither Mr. Ali nor any counsel appearing could lay hand to it. Section 5 was repealed by virtue of section 39 Act. That
only
is
the
what is.
headline, only the headline of the section
But
5
what
Act.
was originally the section 5 was not. We don't know what was there.
If your lordship may kindly can draw an inference
That
the
is what is
39 Act,
whether this inference on this notion can be granted without looking at the original section 5.
we have tried our level best, my lord. In the internet, the 37 Act, the amended 37 Act is not available. Pre-amended 37 Act, my lord, we have tried our level best. But if your lordship may kindly consider section 6 of the 39 Act, by virtue of section 6 of the 39 Act, my lord, section 5 got repealed of the 37 Act.
True, that is what I was just thinking, that what was there. You are expounding a law that section 5, which originally stood in 1937 Act, is an exception to section 2.
My lord.
in order to arrive at this decision, one has to understand that whether it is really it was really an exception or it was not an exception. You said that the inference can be drawn when the 39 Act came into force and the Section 5 was repealed. So it was a codification in relation to dissolution of marriage,
by Muslim.
which 39 Act itself stand exception to Section 2.
Right.
I
My-
got your point. This is what you want to, but in order to say so, one has to look at Section 5.
My lord.
Nobody.
And I am extremely sorry because, my lord, we cannot be of any assistance because we could not, my lord. Despite best endeavors, my lord, the pre-amended 37 Act, my lord, we could not find. Even, my lord, till yesterday. We searched the old books. So this is a predicament that, my lord, we are facing. And the rest lordships would kindly consider.
What is the meaning of the expression consolidate and clarify?
My lord, to my understanding, my lord, I might be sounding very naive, my lord. To my understanding, my lord, what was not there or what was incomplete in Section 5.
So you consider yourself as a knife.
My lord.
Yes.
My lord, what was not there in the, or what was rather incomplete in the Section
But
5.
there are
37
many acts which consolidate and amend. Many acts, the expressions are, they act to consolidate and amend. Many acts consolidate and enact, consolidate and clarify. What meaning can be given to those expressions?
My lord, we were also discussing, my lord, for example, my lord, Juvenile Justice Act came in 1986. My lord, prior to that, my lord, CRPC and IPC had certain provisions. It only said that for a person who is aged less than 18 years, for that person, the trial will be, my lord, or the inquiry will be at certain place different from the place where the adults are tried. But the other provisions remain the same. The punishment, the process of trial remain the same. 86 Act, my lord, came and, my lord, consolidated the laws relating to juveniles.
So what emerged therefrom in that event?
That, my lord, from 86 onwards, my lord, the CRPC and IPC would have, my lord, a limited scope and application so far as, my lord, children in conflict of law, children in conflict with law. So, my lord, this Juvenile Justice Act consolidated. My lord, I'm being. No.
Whatever my lord has indicated in the last occasion, I wanted to find out the unamended copy. When I could not.
Look at the Code of Civil Procedure. The preamble of the act also says consolidate and amend the laws relating to the procedure of the courts of civil judicature. And that's why this phrase or the expressions consolidate and amend, consolidate and clarify, this has to be understood. So that is what I wanted, because Mr. Ali was saying that's a consolidation of law. Then if it is definitely it's a consolidation. Then what message it conveys? Consolidation is a compilation, reconciliations of the various provisions already in existence, or it is something which stands alone, creating an exceptions to what is already there in any other act, or it supersedes any other act, and this applies. That was that.
এখান থেকে দিচ্ছি, ওখান থেকে।
ওইটা
Your Lordship, my lord, was indicating, as your Lordship was indicating, my lord, in the preamble of the dissolution of Muslim Marriage Act 1939,
it is
there is
to
an indication,
consider,
act to
consolidate,
consolidate
and
and clarify.
clarify. And in various acts, if you find, look at it. Look at this. Look at the preambles of these acts. Just above section 1.
Act to consolidate and amend the law.
There are two
Related to
expressions. That is what I say. Consolidate and amend. And consolidate and clarify. These are the two expressions. The next civil procedure code is also the consolidate and amend. So this difference, consolidation and amendment, and consolidation and clarification.
Clarification.
how it is to be interpreted.
It appears, my lord, subject to, because my lord, your lordship has gone deep into the matter, which I cannot say, I cannot add words. But however, my lord, I submit that consolidation and amendment, it seems, my lord, that consolidation and amendment stands in a different footing from consolidation and clarify. Because clarification of the other law, that is the, my lord, before 1939 Act, that was subject to, my lord, subject to correction of your lordship's, my lord, that was taken care of, and my lord, this was, legislature was drafted. Subject to correction of my lords. Because clarification and amendment, these are two nomenclature of the words. Amendment, whether it includes clarification, not at all. I say, Willard, it does not. That your lordship may kindly take care of. I can say this much. I cannot say anything more. Consolidate and clarify.
Same thing. Clarify at the same time.
সেটা বলছি তো যে এই অ্যাক্ট অফ 1939 it has gone down into the act of 37 has gone into the act of 13.
Expedient to consolidate and clarify the provisions of Muslim law relating to source disputes from marriage by women married under Muslim law and to remove doubts to the effect of the renunciation of Islam by married Muslim women on a marriage time.
Difference between correct and amend. So clarification. Correction also. Clarify definition কি আছে? Clarification is not যেটা আগেরটাই
Whether it can take knowledge.
Clarify the provision of Muslim.
My which is an answer. No. Hey. Look at paragraph 9 and show it to Mr. Ali as well.
সেখানে আমি একটু ইয়েটা দেখে নিই, একটু লিখে রাখ। 2007 ভলিউম 2 এসএসসি 551, 2007 ভলিউম 2 এসএসসি 551।
What is the meaning of consolidation? It's given in paragraph 9. Please read.
559.
It is a different question whether a suit may be bad for misjoinder of parties or misjoinder of cause of action is a suit barred by law in terms of Order 7, Rule 11D of the Code. The Code of Civil Procedure and its preamble indicates is an act to consolidate and amend the laws relating to the procedure of the courts of civil jurisdiction, civil judicature. No doubt, it also deals with certain substantive rights, but as the preamble vouchsafes, the object essentially is to consolidate the law relating to civil procedure. The very object of consolidation is to collect the law bearing upon the particular subject and in bringing it up to date. A consolidating act is to be construed by examining the language of such a statute and giving it its natural meaning, uninfluenced by considerations derived from the previous state of law.
Then
Consolidation and
Uninfluenced by considerations derived from
consolidation and
the conclusion.
derive from
শুরু হচ্ছে
So it is
consolidation and amend.
Yes.
Yes.
no
Consolidation. And
there are two things I did. Consolidate and amend. The Supreme Court was primarily dealing with the word consolidation. And then the question of amendment later on. But consolidation has been defined to mean here that it says that, but as the preamble vouchsafes the object vouchsafes the object essentially. Now, where is vouchsafes the object of essentially is to consolidate the law relating to civil procedure. The very object of consolidation is, kindly consider, to collect the law.
what she is referring to paragraph 9.
Right.
Paragraph 9.
Placetum, I'm reading just in between placetum C and D. No doubt. It deals with the procedure of the Court of Civil Judicature. No doubt it also deals with certain substantive rights. But as the preamble vouchsafes, the object essentially is to consolidate the law relating to civil procedure. The very object of consolidation is to collect the law bearing upon a particular subject and in bringing it up to date.
Right.
A consolidating act is to be construed by examining the language of such statute and by giving its natural meaning, uninfluenced, please, by the considerations derived from the previous state of law. Previous state of law.
Very right. I'll make my observation on that. Yes.
That word previous state of law is the
The word used is previous state of law, previous law. Previous law. Where both the laws are there before your lordship. Both 37 and 39. Both 37 and 39 are there. Let me conclude if your lordship so pleases in that can falls upon me, my lord, I'll answer to that.
then come to paragraph 18 also of the same judgment. It cannot be disputed that the court has power to consolidate suits in appropriate cases. Consolidation is a process by which two or more causes or the matters are by order of the court combined or united and treated as one cause of the matter. The main purpose of consolidation is to therefore save costs. The jurisdiction to consolidate arises when there are two or more matters or causes pending in the court and appears to the court in this. So there, it's a consolidation of the suit, but the interpretation of the consolidation is derived therefrom. That is, there are more or one, there are more than one which is operating in the field. Then they are to be combined. And the moment the combination means it is a one standalone.
Is consolidation of suits.
This is relating to suits, no doubt about it. I am just, you are correct. This is relating to suits. But the analogy which I was just deriving therefrom, that if there are more than one thing which is operating, and then these are there, then in order to bring it into one compass, or within a one, the contour, then in that event, consolidation has to be understood in that. This is what apparently, I do not know ultimately where it will head, subject to what to do. All are handicapped.
So far as I am concerned,
No, all are handicapped.
I cannot say it.
Rather, we are unable to find out the original Section 5, nor Mr. Ali is in a position to find out what was there in original Section 5. Everybody is handicapped. Then what to do? Because I could not lay hand to any of the act where this word clarify is actually used. I have an occasion to look at many acts, as I have given 2-3 acts where it says consolidate and amend. I had an occasion to see that consolidate and enact. But this is the first time I could come to know consolidate and clarify. Yes. No improvement.
Can I make
Yes.
a comment? Lordship have gone so much. Can I make a comment?
No, no. Let us think over it, Mr. We conclude there is nothing to add.
Yes.
I believe something to.
CAV, that's the expression.
No, on 37 and 39. Well, the act actually, which is disturbing the mind of the court as far as I could understand, subject to your lordship's pardon
Yes.
to me. Well, that which is really disturbing the mind of the court, as far as I could understand, subject to your lordship's kind pardon to me. That is section 5. What were the unrepealed section 5? That is one part. Let us take these 2 acts, 37 and 30. If we could find, I am trying my best, my lord, to find out an answer as to what was the unrepealed section. 1. And number 2, as to whether it is at all necessary. But before I go on to that, my lord, very humbly I would submit the analogy my learned friend has submitted about the Juvenile Justice Act. Juvenile justice is altogether on a different domain. And we are altogether in a... That's not the custom of the court, Baba. It is শিখে আসিনি আমরা। Well, that's actually, that is altogether on a different domain. That is the general law. But now, my lord, in this afternoon, we are hovering around a personal law, which really gives a wide distinction between the general law of the land and the personal law of a particular community. Therefore, we are altogether on a different domain. We are altogether on a different domain. Let us examine what those 2 particular laws with regard to a question which is agitating us, but can be found out from there. My lord, 37 Act, your lordship kindly takes up this 37 Act. Act, in Mr. Mukherjee's compilation, my lord, in 37 Act, lordship will get kindly straightway goes to the last page of Mr. Mukherjee's compilation. The last page, my lord. Your lordship got it. The last page of the 37 Act. Lordship kindly takes up section 5. 5. The last page, 68. 5. 5 says, dissolution of Muslim marriage by court in certain circumstances. Your lordship found it. Repealed by the Dissolution of Muslim Marriages Act 1939, section 6, with effect from 17 March 1939 is very important. 17 March 1939. Now your lordship goes to 39 Act. That is at page 50 of Mr. Mukherjee's compilation. 39 Act says, the question, my lord, agitated question, consolidate and clarify the provisions of Muslim law relating to suits for dissolution of marriage, so and so, 17 March 1939. This 39 Act comes into force on 17 March 1939. And 37 Act, Section 5, it is dissolved, dissolution of marriage. By the Dissolution of Muslim Marriages Act 1939, Section 6, with effect from 17. What is Section 6? Well, the undermentioned provisions, the Act and regulation mentioned below shall be repealed so far as they are inconsistent with the provision of this Act. Well, certain acts are there, certain provisions. Section 26 of Bombay Regulation and all these. So Section 5 of the 37 Act of Section 5 has been repealed by the Section 5 of the 37 Act was repealed. The same thing is to be found at page 51 of the 39 Act. At page 59, 6. Repeal of Section 5 by repealing and amending Act of 1942. In 1942, that Act has been repealed. Section 5 of the 37 Act. Now, what is the repealing Act? Well, I am taking the questions to something else. The repealing Act is an act. It is a particular privilege of the legislature to enact a law, a privilege, a right of the legislature, inherent power of the legislature to enact a law, to amend a law, to consolidate a law. So when it is a repealing act, this repealing act, by the repealing act, the legislature thought it fit that this particular provision of dissolution of marriage by court in certain circumstances have been repealed. It is the legislature thought it fit that it has to be repealed. So they did repeal. Therefore, and that too, it was repealed in 1942. And after 42, my lord, on this question, on this act as to whether a Muslim woman has a personal law, being the Muslim marriage a law of contract, can, with the consent of the other parties, go out of the marriage. That was revealed in 1942, the intervention of the court. Should in 1923, we think about the intervention of the court for a dissolution of a Muslim marriage by a talaq-e-tawfiq, which is a personal law, and that the procedure of personal law has to be applied. So in this context, my lord, my respectful submission will be that these two acts, along with the amending act, is the particular privilege, the inherent legislative power by exercising which, my lord, these two acts have been enacted, along with the repealing act too. So in that event, my lord, Section 5 is no longer there, the intervention of the court. And the intervention of the court, my lord, I was going to suggest, well, I have already placed that. That is AIR 1961, I believe. Yes, AIR 1961 Supreme Court, 808. AIR 1968 Supreme Court 808, where it is the Supreme Court delivering the judgment in February 1961, not 42. In 61, delivering the judgment, internal page 6. Internal page 6, towards the middle. Your Lordship says 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10th line. It is expressly. 10th line. It is expressly enacted. It is expressly enacted in the Shariat Act as amended that in all questions relating to the Muslim personal law, relating to the matters specified, the rule of decision, quote unquote, the rule of decision in cases where the parties are Muslims shall be Muslim personal law. That is what the Supreme Court says. Law, the injunction is one directed against the court. But with deep respect, I will try to emphasize upon this observation of the Supreme Court. The injunction is one directed against the court. It is enjoined to apply the Muslim personal law in all cases relating to the matters specified, notwithstanding any custom or usage to the contrary. So, my lord, even if we are very jittery to bring into the domain of the court in respect of a dissolution of a Muslim marriage by talaq-e-tawfiq, which is recognized by the Muslim law, that the court should intervene, my lord, it would have been better. But unfortunately, the law is so. That is the solution. An injunction against the court.
But Mr. Ali, there are 2 or 3 things which is still grappling our mind with these situations. 61 Act is absolutely categorical and clear on this because it does not relate to a dissolution of marriage by a Muslim woman.
For relation?
61 Act does not really relate to a dissolution concept. It is in relation to the properties or a declaration, something. No, it was not there because it says then
39 Act.
No, declaration of consequential is there. If you look at the real cause which have been enacted.
Your Lordship refers to the judgment?
Yes, 61 Act itself.
Judgment.
And then
just a moment.
It is in relation to the applicability of 37 Act. If you come, if I read you, then
yes,
the question was,
yes,
the question was, if you come to internal page 4, at the bottom right hand side, you will find, I can take you from that page itself because the cause of action would be there. Right hand side bottom, you will find the page number.
yes,
Have you got that?
yes.
So if you come
at page 4.
Internal page 4 at the bottom right hand side, very small font. In a small font, it is where you have kept your finger, index finger,
Yes.
there, 4, page 4.
Yes, page 4.
Yes, top, if you come.
Yes.
They denied the right of the plaintiff kindly to a share in the income, contending that lay custom in the family, females were excluded from inheritance, that the office of a pashimam, khatib, and muzawar could only held by the males and the females were excluded from those offices. That the plaintiff claim was barred by law of limitation, and in any event, the suit for mere declaration was not maintainable. The trial judge held, and the appellate court agreed with him, that there was an immemorial custom governing the institutions precluding the plaintiff from performing services or sharing the income, emoluments, and perquisites, and therefore the plaintiffs were not entitled to perform those services.
That the question here in this case?
I'm saying it is not. When you are referring section 61, that's why I say these observations has to be read in the perspective of the facts involved therein. Then, and enjoy the surplus income. And accordingly, they were not entitled to a declaration of injunctions prayed for. In second appeal, the High Court of Madras held that by virtue of a Shariat Act, now it comes 37, the income received from the institution had to be shared according to the personal law of the parties, and the plaintiff's claim was not barred by the law of limitation, nor was a suit open to objection that it was framed not maintainable. Against the decree passed by the High Court, this appeal with the special petition under section. So question was an entitlement to have the income and emoluments or a perquisites to be enjoyed by a male, and a personal law that really fetters the female to perform those. It was in relation to a customary right. It was in relation to a kind of a inheritance, if I say in that succession in that sense. And in that perspective, it was held the moment the Shariat Act of 1937 came into force. And by virtue of section 2, which starts with a non-obstante clause that notwithstanding anything contained in any custom or the uses.
Regarding?
That is what I'm saying.
Regarding the items used in 37 Act.
No, that is what, no, that is not there.
No.
So it says
37
it's
Act,
according to notwithstanding contained. This is what is quoted also. The next page at the bottom, you will find the quotation. Notwithstanding any custom or uses to the contrary at page 5. Quotation, that's section 2. In all questions related to interstate succession, is special property of the female, including the personal property, inherited or obtained. Page 5, bottom, section 2 is quoted. So, non-obstante clause is in relation to a usage or a custom to the contrary. And then say that any custom or uses which is contrary to the personal law, those have been superseded by virtue of the Shariat Act, and it says that those would be decided according to the Muslim personal law, irrespective of the fact that there is a different customs and the uses. So the primacy to a personal law has been retained. It will abide by that. In that perspective, and in the perspective of that fact, where the female was really claiming that I am entitled to have the income, I am entitled to have the privilege, I am entitled to have the emolument of this. This observation of the Supreme Court came that no, 37 Act is a standalone, is a paramount act, and the moment it saves the personal law, it is the personal law which will govern, no doubt. But the question would have been different. If there is a codification, it's not a codification, I stand amended. If there is a law on a particular subject, which is also contained in section 2.
Yes.
But section 5 was retained.
Section 5?
5 was retained.
In which act?
37 Act.
This is in respect
relating to the dissolution of marriage by woman. Section 5 was there. You can't deny it was not there.
in 37?
37.
Yes.
Section 5 was there
Yes.
originally.
Yes.
What section 5 as it appears was in relation to a dissolution of marriage by a Muslim woman.
Yes.
It appears from there.
Marriage.
Then first question that really comes, that section 2 being very categorical, why there was a necessity to incorporate section 5? And in a canon of interpretation of a statute, you know, the last word in the statute has to be taken,
I beg to differ, my lord.
has to be taken.
Yes, I beg to differ.
GP Singh has
Statute has to be.
the GP Singh has interpreted in the there is a chapter in this regard
Oh, yes.
where it says then first and foremost duty of the court
Yes.
is to harmonize all the sections.
Well, with due respect, I should submit, my lord. My lord, the statute has not to be interpreted with regard to a particular word or a particular section. The statute as a whole has a scheme.
No, I understand. That
The
is a
total
purposive,
statute has to be
Mr. Ali,
interpreted.
that is a concept of a
Yes, my lord,
purposive
that is the
construction.
rule of interpretation of the statute.
But there is a first primary duty, or the first line of the interpretation rule is the literal. If the words or the language used in the statute is absolutely clear, unambiguous, does not invite any second possibilities, then that has to be resorted first. If there is some kind of an ambiguity, some kind of an interpretative process, then it is to be decided in perspective of the object, the purpose, the reasons for enacting those laws. That comes in a later point of time. Here we are into that situation. What I gather from all these judgments are, forget about 61, what it says. Definitely the personal law is there. There are two situations that emerged in this case. Situation A, where the husband has already given or delegated the authority or given a consent to the wife to get the dissolution of marriage. Under the personal law, there are 3 or 4 modes, which includes the talaq-e-tawfiz, where the Muslim woman can seek the dissolution, exercising the authority given to her by her husband, and then can move out of the institution of marriage. That's recognized under the personal law, no doubt. If that being the position, then there was no question of any enactment or a consolidation of the act relating to dissolution of marriage by a Muslim woman. The second situation may come, leading that why this act was enacted. That may come. Second situation is that where the husband did not delegate the power upon the wife, nor gave that consent, nor something has been done. Does it mean that because of the personal law, the wife is compelled to remain in institution of the marriage throughout her life? That does not appear to be rational and reasonable. She must get an opportunity to get out of the institution.
Marriage.
Maybe for that reason, this 39 Act was enacted, where it says that in such event where the consent or delegation has not been given by the husband, yet the wife can seek a divorce,
In which
dissolution.
In, which case? In what circumstances?
I'm coming.
Yes.
Seek a divorce, provided the grounds enumerated therein are satisfied.
1 to 8.
9. You are omitting 9, which is a very important one.
1 to 8.
1 to 9.
And 9 is very important.
That's why I'm saying 1 to 9.
Yes, my lord.
Roman 1 to Roman 9. You can't avoid Roman 9.
Roman 9 is there.
Yes. So these are the grounds where she can seek a divorce.
Yes.
So what apparently one can think of, that this act applies in a particular situation and does not abrogate or supersede the personal law,
Yes.
which is maintainable or which is applicable in view of 37 Act.
Yes.
Object is silent. Object is silent. It does not say in such situations.
No.
It does not say so.
No, it is not.
It is absolutely a generalized the act relating to suit for dissolution by the Muslim woman. Then question is why 9 was introduced. If a ground is valid under the personal law for dissolution of marriage, can there be a ground under under the Act of 39? Can't be a ground. It has to be omitted. Should not have been there.
Does it give any power to the court?
If the power of the court to grant a decree,
Is it there?
a decree is there, because that is one of the
No,
ground. If the court is satisfied that
We are
yes,
dwelling upon 39.
yes,
We are dwelling upon
yes,
39.
39. That's why I'm saying
Give
39.
Power to the court.
Yes, that is what I'm saying.
Yes.
It is given. The power is given upon the court to grant a decree.
My lord, I deeply, my lord,
Because if you look at the language,
I regret to research, my lord.
no, it's a healthy discussion, Mr. Ali. It's because we have to arrive at the very correct decision.
Because, my lord.
What is
because
troubling
Roman-
our mind is
to
I'm
that.
expressing.
Roman 9 is answer to that.
According to,
Legislators have taken
yes,
note of that situation.
yes,
Roman 9,
yes,
on any other ground,
yes. Now look at it. The next words.
before me,
Yes, look at it, the next words.
yes, on any other ground,
Yes,
which is recognized
because,
as valid.
yes. Now I am saying
No,
if
I'm
it is a
coming.
validity is the important factor.
Well, let me conclude this.
Yes,
On any other ground,
yes,
which is recognized as valid
yes,
for the dissolution of marriages
correct,
under Muslim law.
correct. What could be?
There is no, my lord,
What
There-
could be a ground which is valid, recognized as valid for dissolution?
in that event, we have to go to 37. We have to go to, because 9 is an incorporation in 39 Act. 9 is an incorporation in 39 Act. And in 37 Act, what are the grounds stated there? Well, in section 2.
It says the personal law in relation to a marriage and the dissolution of marriage. No, nothing has said. No ground is required.
Yes, yes.
It says only the personal law.
No,
Look at that.
well, yes, 2.
Look at that.
2 is still there.
Yes, I'm not disputing.
Well, 2, what does it 2 says? And why this any other ground?
Yes,
Well, 2 says, not you clearly see. Personal law, marriage,
yes.
dissolution of marriage,
Hmm. No, you are
Including.
talking about the talak.
dissolution of marriage including,
That's why I'm saying you are talking about talak.
yes, including talak, ila,
Ila
Yeah.
is not applicable to women.
ila.
Hmm.
What is ila, my lord? It is a conjugal relationship. In conjugal relationship, sexual intercourse is a must. Until and unless this marital relationship is
And
there,
what about
ila,
zihar? What about zihar?
ila,
No, I understand. What is zihar?
the man is important.
What is zihar?
The man is important.
No, I understand.
Jihad
What is
an
zihar?
act. Yes, jihad. Let us see. Then we have to go again, my lord, to that.
So
What is
if
ila,
that
what
being,
is jihad?
no, if that being the position,
Yes.
then if you come to
I have placed all this, my lord, you can then.
if you come to the 39
Ila.
Act, then
There is ila,
yes.
Shihar, Lien, Khula, and Mubarak. All these are there. All these things.
Then if the ila is the
Tawfiz is not there.
Mr. Ali, if the
Talaq and
ila,
tawfiz is not there.
if the ila has that interpretation which you just gave, then what was the necessity of incorporating ground number 5
On any
in
other.
39
yeah.
Act? Ground number 5, not 9.
No. In
5.
9 I am saying.
I'm talking about 5.
5.
Yes, ground number 5. Then what was the necessity? If the
Tawfiz is
ila
there.
is already there, then this
Tawfiz
could
is
happen.
not- Talaq Tawfiz is not there.
No, talak e
In
tawfiq.
section 2.
I understand. That is what I'm saying.
Yeah, that is why any other ground. Recognized by Muslim law.
True. I'm just saying that what does it connote? What does it connote? That if the incidences of talak or dissolution of marriage, may I be very specific, because talak is used in singularly there. So I'm not using the word talak. Let us see in a dissolution of marriage, if the various modes have been provided, then those modes are saved under the personal law by virtue of section 2 and does not require intervention of the court. Does not require intervention of the court.
Nowhere in these two acts.
But I
after
find
the
that,
amendment.
if grounds have been given,
Honorable, my submission is, under these two acts, after the amendment, I did not find, according to my intelligence, that in a case of Muslim marriage, which is nothing but a contract,
correct.
that the intervention of the court is necessary, that one party should go out of the court is to the court and matopuri kon dorkar nei. Absolutely court is injuncted. If two parties enter into an agreement and one party has to go out, then is it necessary that the court should intervene that you go out of the contract? Absolutely not necessary. इलाका के बोले देखिए
I was just wondering when you were arguing, I was just thinking aloud because something was really going in my mind. That when the Hindu law, there was a lot of, the debate prior to 1955 or 56, because there were several scholars and there were several, may I use the word, the rishis, that's a Manu, Yagyaval, there are many. They have a different forms and there was a varied form.
Dear Lord, she wanted to know what is Ila. It is a kind of constructive divorce in cases where the husband observes abstinence from sexual intercourse for a period
That's a
of not
conjugation.
less than
That's a
4 months.
conjugation. That's a consummation. So I was just wondering that. Then I find from a Hindu Marriage Act, the preamble says that the act to amend and codify.
Yes. Not considered.
Very, very important factor. It codifies the law relating to marriage among the Hindus. It says. Then when the Hindu Succession Act came into force at a later year, in the next year, it also talks about the amend and codify. So that codification is a very important factor,
Right.
which one has to understand. And the same thing which I find in the Minority and Guardianship Act, where it says an act to
Is one of
amend
the Hindu
and
courts.
codify.
Is one of the Hindu courts.
That's true. Hindu Minority and Guardianship Act, not the Guardians and Wards Act. No, it's a Hindu Minority and Guardianship Act.
Yeah.
So it also talks about the act to amend and codify.
Yeah.
These I could lay hand to it that in those period of 1955 and 56, because the Hindu Marriage Act came 1 year earlier than the codification of the Hindu law latter. That was of 1955, it was 1956, and all the laws in relation thereto says they amend and codify the law.
And codified, yes.
So that was a codification of law. When the Indian Succession Act was introduced, which was earlier,
Yes.
then you will find, so far as the Indian Succession Act is concerned,
Indian Succession Act is after Hindu Succession Act.
no, it's not it's a Indian Succession Act is because the very first section, I say, section 4 says, this part shall not apply if the deceased was a Hindu, Muslim, Buddhist, Sikh or Jain. So there are certain things where certain provisions have been excluded.
Yes.
So it says an act to consolidate the law
Yes.
applicable to intestate and testate succession. That's all. It does not say to whom. It does not talk about any religion or religious belief. It simply says an act to consolidate the law applicable to intestate and testate succession.
Relating to which one of this?
Not relating to it.
Hindu
Nothing.
succession. It is Hindu succession act.
Nothing. Indian Succession Act I am talking about.
Indian succession act.
That's of 1925.
Yes.
Britishers' time, continued.
Yes.
It simply says consolidate the law relating to intestate and testate succession.
Yes.
That's the another thing which I find the distinctive features.
Yes.
If you look at the General Clauses Act, then is also you will find an act to consolidate
Yes.
and extend the General Clauses Act of 1868 and 1887. So in all the cases where the first thing is amend and codify, the moment the codification comes and everything is amended, then it is the last
Yes.
statute which has to apply because it has been codified.
So that is an act by the Indian legislature.
True.
It is by an act of the Indian legislature.
Correct. That's why I was just saying that the codification and amendment, that whatever is there is amended and now it is being codified.
37 and 39 act and not Indian legislature.
No. Mr. Ali, when we are discussing in a broader perspective. Please do not consider according to your case. Let us consider it in a general perception. Will definitely come. There's no difficulty in our mind. What we are trying to understand is that what is the meaning of that particular word, the act to consolidate and clarify. We have to find the answer from there. So different ways of enacting a law. As I say, one way of enacting a law is amend and codify, which really abrogates whatever was there earlier and now it's a codified law. It has to be followed in that fashion. One is a consolidate and extend. What is to be extended is this. And one is the codification, and there is another word which is used. One is only the consolidation. There is no other word used.
Consolidation.
It is only the consolidation.
There is another one. Consolidation and consolidate and clarify.
That is what I say.
Consolidate and
That is why one has to understand first the meaning of consolidation.
Consolidation, yes.
And then we have to use the further words. One, if it is an extension, then one has to interpret what is the meaning of that extension. If it is a clarification, then one has to understand the meaning of the clarification. So this is what I was just trying to figure out.
If we stop at that point, consolidate and clarify, what are you consolidating? What are you clarifying?
That is what is the answer.
The provisions of Muslim law.
Correct.
And not only Muslim law. There are vast sea of Muslim law. But Muslim law of what? Relating to suits for dissolution of marriage, married woman under Muslim law, and to remove doubts as to the effects of renunciation of Islam by a married Muslim woman on her marriage side. Well, the total sentence, my lord, in my respectful
That is what one has to understand the
quite clear.
both.
This is all relating to Muslim marriage. The consolidation and clarify the provisions of Muslim law relating to suits. It is all relating to suits of a Muslim marriage. It is not a codification. My lord, codification and consolidation are two different completely, yes.
No doubt.
Are two different concepts.
No doubt. No
Yes.
doubt.
And when academically discussing consolidation and codification, but if we want to discuss it academically, that may not codification a question that doesn't come here.
No. One reason is in order to ascertain once it is a codification, that
Yes.
means it abrogates, supersedes the earlier the notion.
Not always. Not always. My lord, if codification is there, not always. Even in codification, certain law is retained, certain law is already abrogated. There are enough umpteen number of case laws.
There are umpteen number of laws. For instance, the Indian Succession Act. In the Indian Succession Act and Hindu Succession Act, the Indian Succession Act relates to testamentary succession. And Indian Succession Act relates to testamentary succession. So also Hindu Succession Act. But there are presence of these two acts as well. It's there. It is there.
Probably I am not very clear to you. Maybe my shortcoming in this regard.
It's not.
What I was just trying to say, Mr. Ali, what was I trying to
I'm
say
saying-
that when these laws relating to Hindus, they were amended and codified. That means there were several perception about the Hindu laws prevalent in a different section of the Hindu society, where you will find there were a different kind of a succession, there were a different kind of a marriage, there were different things.
Correct.
The once it codify, that it is a codification, then in that event, unless there is an express provision in the codified law, then it is a codified law which supersedes, overreach all those customaries or the laws relating to the Hindus prevalent in different societies in a different way. Look at this. A Hindu, previously there was a concept of more than one marriage. In the Hindus also, prior to 1956, there was no embargo. There was no embargo that how to go for a divorce or how to deal with those situations. There was nothing of that kind. The moment the codification comes, then it becomes a law, codified law, that now this institution, marriage is an institution. Nobody can deny it. So this institution will be governed by the law.
Yes.
And nobody can do it irrespective of anything or a custom which was prevalent. So this codification comes that it is to apply, which has to be considered as distinct and a different from a law which is consolidated and or extended or a consolidated and or clarified. Two different concepts. You can't bring codification into that concept. It's absolutely different.
Well, with deep respect, my lord, codification of a law, my lord, it may be codification with respect to a particular aspect of human law, of human society, of a society. For instance, the Hindu Marriage Act. The Hindu Marriage Act, it is a codification. But even in that codification, even after that codification, my lord, the matrimonial system, the marriage system, the institutional system of marriage, in case of Hindu, as covered by other sects of the Hindus, are still there in vogue.
Oh,
The Punjabi marriage is a different one. Punjabis are Hindus. Yes. As far as I know, my lord, that नहीं तो चाल अभी देखता कोई हिंदू मैरिज है laws relating to marriage.
yes.
Laws relating to marriage.
I'm giving you section 2 of the Hindu Marriage Act. When you talk about, I says this act applies to any person who is a Hindu by religion in any
Why?
of its Hindu by religion
Yes.
in any of its forms or developments,
Yes.
including Virashaiva, Lingayat, or the follower of the Brahmo, Prarthana, or Arya Samaj.
Is Sikh Hindu?
Or a
Is
Samaj.
Sikh Hindu?
No, I'm just
Yeah.
coming, sir. To any person, I'm giving an answer because section 2 talks about that.
Yes.
Then first situation I have read, B is an answer to what you say. To any person who is Buddhist, Jaina, or Sikh by religion. So Hindu Marriage Act. And 3, to any person domiciled in territory to which this act extends. Kindly, domiciled in this territory to which this act extends, and then excludes whom? Extends who is not a Muslim, Christian, Parsi, or Jew by religion, unless it is proved that any such person would not have been governed by a Hindu law or by any custom or uses as a part of that law in respect of any of those matters dealt with herein, if this act had not been passed. So this is what the applicability of the act says so.
This applicability of section 2, my lord, your lordship finds, my lord, there also certain sections, those who are not included by religion Hindu, that Parsi, Buddhists, Sikhs, Jains are excluded, though it is a codification. Though Hindu Marriage Act
Is a major debate, Mr. Ali. No,
it is
I
a major
tell you,
So
the Christians
therefore,
can't be termed as a
law of the legislation, if there it is, then in that case, the court is not to legislate.
But the difficulty explanation is given that the following persons are Hindus, Buddhists, Jains, and Sikhs by religion, as the case may be.
Therefore,
Any child,
Although it is a
legitimate or
codification.
illegitimate, both of whose parents are Hindus, Buddhists, Jains, and Sikhs by religion. Any child, illegitimate or legitimate, one of whose parent is a Hindu, Buddhist, Jain, or Sikh by religion, and who is brought up as a member of the tribe, community, group, or a family to which such parents belong or belonged. And any person who is a convert or reconvert to Hindus, Buddhists, Jains, and Sikhs religions. Then it says, notwithstanding anything contained in subsection 1, nothing contained in this act apply to the members of, this is how a very important thing, nobody takes care of that, members of any scheduled tribe within the meaning of clause 25 of article 366 of the Constitution, unless the central government by notification in official gazette otherwise directs.
So therefore, the flow, my lord, if it is there, it is there. And my lord, the Hindu Succession Act or the Hindu Marriage Act of the four legislation on the Hindu Code Bill, as we say, the four legislation. But earlier, my lord, I have also made my submission that it was for Nehru who thought that this is necessary in this country to be done, because we have said equality laws in our very, preamble of the Constitution. And that is why, my lord, earlier, my lord, at the very outset, where I start my argument, my lord, on this particular subject. After being he himself, my lord, elected as president, it was Purushottam Das Tandon who objected. No, you cannot make this Hindu Marriage Act or this Succession Act, all this. You cannot. But even this, my lord, Jawaharlal Nehru, my lord, and after all, even Purushottam Das Tandon, this legislation was made. Because the Constitution is there. And the Constitution says of different hue, different religion, different culture of this. That is altogether what it is. So, my lord, coming to this whole proposition is that. But consolidation, if consolidation with regard to a particular aspect of the citizen's life, not in respect of all. This consolidation in respect of the marriage of a Muslim woman and their dissolution with regard to this one. So, my lord, here in these two particular statutes, 37 and 39, both holding the field as on today, my lord, does not require the sanction of a court or rather a decree of the court in order to get.
I got your point. That's a very specific point you
Talaq-e
have already
Tawfiq, my
taken.
lord. Talaq-e Tawfiq, which is recognized under the Muslim law. And Talaq-e Tawfiq is recognized under the Muslim law. Should I
No doubt. It's there. It's
So,
there.
that is-
No doubt is there. Yes.
If that was the language of our 13 section 13 of this marriage act, There, my lord, the marriage, any marriage, solemnized, may be, may on a petition presented by the husband or the wife. So upon making the application, it has become mandatory for dissolution of the Hindu marriage. Any marriage, my lord, the language is any marriage solemnized, whether before or commencement of this act, may, comma, on a petition presented by either the husband or the wife, be dissolved.
But the language of section 30, Act of 39 is different.
Yes, that is my lord. It
It's
is
a different, it says that the Muslim woman is entitled to a dissolution of marriage.
yes, and my lord, it is only enabling. My lord, a woman married under Muslim law shall be entitled to obtain a decree.
Correct. So that is what is an entitlement means. A right has been conferred upon her.
My lord,
So this is what is.
addition to my lord. In addition to my lord, if the wife,
That is what he
Yes.
says. Mr. Ali's argument is an optional.
optional.
So I gave two situations that it may be that it may not be an optional,
Yes.
but it is applicable. It is applicable in a particular eventualities. This is what I gave her. That is what one has to understood. I gave two situations.
My lord, I am trying to, my lord, the intention of the legislature, when my lord, the making of application mandatory, that language was, my lord, prescribed. And here, my lord, making of application has not been become mandatory. For that reason, my
It's not an application because it is a suit.
yes, yes, my lord, obtain a
Talks-
decree for suit.
And this is only a one-way traffic, sir. It is only the Muslim woman who can
Yes,
come
yes.
forward, not the Muslim man or men.
No,
So it's restricted to a Muslim woman only.
yes. In certain cases.
For this, Mr. Ali has the best answer.
Yes.
Yes, conclude it. CAV.
I personally.
Ms.
grateful-
Bhattacharya, what is the full form of CAV?
Not it.
No.
Your lordships have given much indulgence to me. I am personally.
Yes, what is the full form? It's a Latin word.
CAB ল্যান্ডমার্ক কি আমরা তো তাই জানি
It's a curia advisory vault. Means the court will consider, will deliberate and will be advised.
But in the High Court Parliament corridor, CAB has a different abbreviation.
That is what they were saying.
You should have. No, no. No, no, not court await sorting, no. CAB, my lord, in High Court corridor,
We are live.
লাইক
yes, my lord.
Yes.
My lord, I am much indebted to your lordship that your
Thank you.
lordship has given much indulgence to me.
No.
Give them.
Yes, call the next.
ছোট ম্যাটা কত দূর এগিয়ে গেল যা 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 যা। আরে ছোট ম্যাটা কত দূর ছিল?
ওটা দিয়ে দিন। Yes. তোলা উচিত। Web resolution.
No act is involved. In a presentation form, I find it's indicated no act is involved.
Maybe it's missing. Maybe it's missing.
Yes?
Maybe it's missing. The issue relates.
What? What do you say about this?
I think maybe it's missing.
There is no involvement of act.
Obviously, there's involvement.
Then
Otherwise,
who has signed it? Mr.
yes,
Sheikh Kareem.
yes, a very newcomer.
Yes. Why you say no act is involved?
I should take the responsibility.
Last moment he has been given a wakalatnama. Apparent. Everything has been filled in one ink, and the last moment the name of the advocate and the signature is appearing in a different ink.
Russia is getting stricter day by day.
True. Then what is the necessity? We are uploading everything on the server, and it is very difficult to find out in future if somebody wants to know, because there is no reflection, nothing of that kind. There is not a correct input which is there. No, I understand what happens. I was there for a pretty long time.
A very long time.
So I know what is there, who has done it, who is the person responsible. Don't do that. How long you have joined?
Yeah, very newcomer. Continue,
6 to 8 months.
6 to
8
8
months. Develop a habit that you will fill up the forms. Find out what is there, in which rules it is there, you have to find out, and then don't entrust upon anybody else. You should know. Because you are signing it. If there is anything, then you are responsible.
Responsibility goes on.
Don't just newcomer, don't do that. Develop a practice. Do it everything by yourself. Yes.
No.
What is the order which is under challenge?
Order Lordship will find starts from page 30 itself.
What is the last order?
Yes.
5th January 23.
Okay.
It is fixed in July.
How long? Kindly have a look. There's a bunch of orders. This is making it a voluminous.
Please also keep in mind the reality.
Kindly be with me. The persons are battling from 2009. I have been successful in all the matters in all the departments. But
I do not know. The difficulty is because under Article 323 capital A of the Constitution, the tribunal has been established. Recently, we have come across with the situation where 3 benches of the State Administrative Tribunal is controlled, managed, and I would say run by only one administrative member.
So it's practically a non-functional.
So there are 5 vacancies, including the chairperson of the. So you can't expect one person to do the matters of all.
I'm
the
not
3
expecting.
benches.
That is the reason why I'm over here.
We have on an earlier occasion already issued a mandamus upon the government, including the central government, because the tribunal reform, I think Reform Act or Reformation Act, I do not know, Act was promulgated in 2021 or something.
2020.
So we have already directed immediately to fill up the posts. I think the time has not expired.
Direction last evening, I got information from the letter secretary. That your justice and again, May is the last day of submission. 8th May is the last day for submission of job. Actually, 15th of May for final submission.
This will not solve my purpose. We have.
Then who will solve your problem? Tell me, sir,
For 10
sir,
minutes.
very difficult.
They were to throw me out.
No, it's not a question of throwing.
I am.
We can extend the sympathy. We can extend, definitely we can say,
Relegation would have been sufficient in this my matter.
what relegation?
But kindly be with me for 5 minutes.
What relegation? Relegation is already there. And therefore, the matter is required to be, matter has been listed for hearing on 12th of July. I understand from January to July.
From when it is being heard, if you lordship.
6 months.
Not only that, kindly take up my petition for once. It is from 30 and it runs to 62, 61. 30 days we appeared in a particular matter wherein a department, 2 departments have been given a decision wherein one has already adopted the decision. They are getting all the benefits.
This matter is to be heard ultimately, but
Kindly
now
hear
today's scenario is different. We have
Your
to
lordship
understand.
feels it is really to
We
be heard.
can't be inhuman. We can't be inhuman.
This situation is creating us to be inhuman. We are also being bamboozled like anything. But person concerned, they're from 2009. They're without their pension. In spite, kindly hear me for 5 minutes. Thereafter,
I understand this is the old matter of 2016.
no, not
It's
only that.
pending.
It is initially of 2009.
It is a
Yes,
way of
that's a challenge over the order. That's a challenge
Because
over the order.
whatever. Then there was a fresh cause of action in 2016.
It's not a first.
So
Kindly
now
hear
we are
me
in
for 5 minutes.
2023.
Thereafter, lordship will
Can
feel whether
understand.
it is really is to be pulled back over or lordship can relegate it from here. Kindly hear me for 5 minutes. If your lordship feel, lordship dismiss my matter. Even if the tribunal would have dismissed my matter, I would have been happy. Instead of keeping these things for years. Whenever I appear, this happened. I have to repeat and reiterate same statements every day for 30 days, the matter of 32 days. What is the issue? This issue has been settled in High Court, even Supreme Court have been successful everywhere. But only to this department, since I have to travel over there, I'm keeping this. This is what is called gero legacy. This is exactly the situation is. Kindly hear me. Thereafter, throw me out. At least I would have been sufficient. That would have sufficed my purpose. Kindly hear me for 5 minutes at least.
10 minutes we give.
10 minutes, kindly. Grateful. Thank you. Mano, kindly have a look at the order which is passed in page 126. This is 1999 issue. Kindly have a look. 2009 this order was passed. Kindly have a look. Now reading it for lordship. Second paragraph, Mr. Roy has stated in the background of this case before us, and such background is pursuant to an order of a learned single judge of this court, Calcutta, in the year 1995, the state government was pleased to sanction a specific pay scale in favor of the petitioner. Subsequently, state government also issued instruction for opening service books of the petitioner, which was a long-standing demand of the petitioner. Which Roy further submits in the year 2003. Now, this is important. Person holding similar status like that of the petitioners and serving the North Bengal Medical College have been granted the status of Group D employee in the state government, and their services have been regularized. Mr. Roy submits that when the petitioners have been given the benefits of a specific pay scale with effect from such and such, and the petitioners have been given the effect of ROPAS 98, the service has already been following the stand of the government taken in the relation of the similarly placed persons of North Bengal Medical College. The prayer of the petitioner for the regulation in Group D post in the state government should be favorably considered, and necessary direction to this effect may be given to this tribunal. Now, last paragraph, in view of this position, we like to dispose of this old pending case that is of 1999. We're still in 2023, battling with the same issue.
matter for disposing the appropriate authority to take a decision regarding regulation of the petitioner in Group D post under the state government, along with granting all related benefits to them, and such decision must be taken after considering office record and earlier orders of the state government, and the decision was directed to be taken in 6 months. Now let's see what happened next. Very next page, Lord, she kindly have a look. This is of 2010. Now, this was the two directions which was given. This was the two prayers rather, on the basis of which the matter was disposed of, and subsequent thereto, it now kindly come to page to 129. This will make the situation more lucid. Now, therefore, it is pointed out that for workmen, employees of the hostel mess attached to different medical institutions under the Health and Family Welfare Department, the issue of regulation was put forward before the Finance Department, Government of West Bengal in such and such. Reference was drawn to similarly placed persons in government, non-government colleges, for which Higher Education Department have also moved Finance Department for the regulation. Therefore, there was a direction from the tribunal to decide the issues of the medical staff, and Higher Education Department also placed the similar situated persons to be decided in the issue. Lastly, Finance Department referred the above file with a note that a holistic view concerning both the departments need be taken. Now, what is being stated out here? Health and Family Welfare Department on scrutiny on all records felt that giving all service benefits akin to the government Group D statement requires first a policy decision from the government as a whole regarding their regulation, treating them as regular Group D employee. Hence, unless the regulation issue is settled, Health and Family Welfare Department cannot take a decision unilaterally in this regard. Now, let us see what was the decision as per the tribunal's order, page 30. Or a typed copy on page 131. What was the direction of the tribunal? Is it an order? I put a question to myself. Understand, direct to inform Finance Department has given the observational proposal of Health Department for regulation of mess workers of the different medical colleges and other three issues cannot be accepted in the light of the orders of the Honorable Supreme. This clears the route. This was what was directed to be decided in light of the orders of the, we are not aware what is the order. Even the person is also not aware what is the order. I pause here for a moment. Now, since there were two departments with regard to health, and second was regard to the education. Now let us come page 132. It is a 2014 memo. There has been serious battles over here with regard to these matters. I personally moved around 60 writ petitions, which were tested up to even Supreme Court, and this is the result. Kindly see. Conferment of the status of the non-teaching hostel employees, mess employees. Now, they are also the same. And the benefit of the General Provident Fund and pension to the hostel employees to the state and universities, government-aided colleges, including government general degree colleges and government engineering technology colleges in West Bengal. Therefore, higher education has came out with a policy before this court indicating that they are extending the benefits not only to the writ petitioners herein, but to all the hostel mess workers who are attached to the university and other technical colleges. Now, let us see, if your lordship kindly be with me for 1 minute. There has been even subsequent benefits which was also given pursuant to this, which is on page 137. And if your lordship kindly comes to page 194, lordship will find that this, special bench. Special bench. Special bench. Page. Now, lordship will kindly have a look for 202 for once.
202 for once first. Even the special bench, Lordship will find from page 203, formulated to decide these issues. Now, if your Lordship kindly have a look, what was the reference being made to the special bench? That is, with regard to the question is over here. Lordship will find from page 202. Would the canteen employees and hostel mess employees of education institution be entitled to recognition as Group D staff, irrespective of the fact whether such institution was residential or not? What would be the yardstick in deciding the issue? Memorandum and are satisfied, we feel nothing survives for consideration as far as points raised in reference. Now, in a similar issue, Lordship will find, since I was taking a Lordship on the very first aspect, that is on page 194, if your Lordship do permits me, it starts from 189 with a single judge's judgment. This is page 189. Now, let us see what was the, I'm skipping over the issues. What was the observation of the
Left.
1 minute? Then I have to move. If your Lordship has already closed your Lordship mind.
What do you expect from us?
What I'm on to
That
since this
we will
particular
bypass the tribunal and decide the entire hearing and done the hearing
Yes,
here.
I'm not on.
Or
Kindly relegate the issue.
what relegate an issue? The issue is pending before the tribunal.
So relegate the issue. for
The
decision.
the
They have
tribunal
already
has fixed the
decided
date.
one.
They fixed the date on 12th of September,
This is fixed.
July, sorry.
To be honest, this is fixed and refixed for 30 times.
I find it is not on the 3 or 4 occasions, the hearing, further hearing or hearing has been fixed. Prior thereto, there was a directive. of
Kindly
filing
be with me
affidavit.
with the orders.
Sorry, I
Kindly
have
be-
seen that. I have seen that.
If your Lordship,
You can't, because the councils can
the difficulty
engage a counsel like you who by his persuasive appearance and eloquence
No,
does not.
there has been a division bench order to do this. Kindly hear me for 1 minute. 1 minute is
No.
still left. 1 minute is still left.
Yes.
There has been a division bench judgment few days back stating where Crown Tribunal is not functioning, High Court can work. Kindly be with me. Page 290.
Yes.
And since I am also before the division bench, yes. This is also a matter wherein there has been confirmation of these matters. There has been points being taken. This has to travel before the tribunal. My learned senior took that point. But what is the order of the division? Just a couple of weeks back.
Yes.
Kindly be with me on page 189. Sorry, 289.
What is the division bench?
Yes, division bench, kindly have a look.
What do you
Same.
say that the High Court will, where? Show us.
High Court can.
Yes, look,
Kind-
show
kind-
us, sir, please.
First, it starts from this particular point that this matter ought to have traveled before the tribunal. This was the point.
Show
Yes,
me.
page 289.
If I find that there is no tribunal functioning,
This is stated 289.
please.
Yes.
Show us.
Kindly have a look.
Show us.
For example, 4 lines from the top.
Yes, sir.
For example, when the tribunal is not functioning for a long period
Where
and a
do I
state
get it?
government
Where
employee,
do I get it?
289, 4 lines from top.
Yes. One.
For example, it starts, my Lord Justice Biswas may have got it.
Yes, where is that? For example,
Oh, yeah.
yes.
Yes.
When a tribunal is not functioning for a long period and a state government employee has an extremely urgent matter in High Court, can exercise in inherent powers under Article 226 of the Constitution of India. It is to be remembered that
It's
when
an inherent powers under Article 226,
yes,
or is a power of judicial review.
this was also the situation wherein
It is a term as a plenary powers.
it was also lordship is if your lordship is not hearing me, this is difficult to make the court understand, to be honest. If your lordship has already closed your lordship mind,
There
then
is
even
already
hearing at
there
my-
is already a system. A person is only one person who is otherwise agreeable to hear out the matter. You have also consented that yes, the hearing should be taken.
This is
may have
not
been taken
becoming,
by
I'm
a
telling you
single-
honestly,
by a
whenever
single
it
judge.
touches the hearing,
What-
it
this is
it is being
comes.
given a later
What
date.
comes. Yes.
Not a single day hearing matters are being conducted. Only the maximum the admissions are being done. If your lordship disbelieves me, that's a different aspect. Lordship may ask anybody. Not a single matter is being heard. They are all retired employees. All other persons are getting. I have been successful even up to Supreme Court, and this is only being lying. Had this would have been dismissed, even I would have been over here.
How can look at this observation at page 288?
228.
288.
288.
It says when now the question is whether the plea that the entertainment of the writ petition and passing an order adjudicating the same was a nullity can be taken at this stage when the plea of jurisdiction was not raised at the first instance. Answer is no, no. Answer is yes. Nullity strikes at the root.
But it runs in my favor at the end of the day. Kindly have a look at the order.
So it is now well settled that the existence of an alternative remedy is not an absolute bar to entertaining a writ petition. Agree. When there is an existence of an alternative remedy, the writ court may exercise some self-imposed restraint in entertaining a writ petition.
Yes, here it
May
was
entertain the
interest
same
of
in the interest-
justice.
Please. The position is slightly different in case of an administrative tribunal which are constituted to adjudicate the dispute with regard to recruitment, promotion, transfer or something of that kind. As already constituted, the government employees are to exhaust their remedy before the tribunal at the first instance. This is L. Chandra Kumar says. Only in a rare case can the High Court entertain a writ
Yes.
petition in service matter where the administrative tribunal is constituted. For example, when a tribunal, it is a different, when the.
This is
act
not functioning at all.
Please, it is a functional. Restrictively, it functions restrictively. It's not, you can't say it's not functional.
Can it be said to be a functioning
Sir,
tribunal?
whatever is there, again I say, there is a distinction that there is no establishment of the tribunal. Then the
Yes.
High Court will definitely, because of the principles that nobody can be rendered remediless.
No, nobody will render remediless. This is becoming remediless.
So what is this? UBI or EB just. Yes. UBI just or EB remedium. This is what is a concept. But when there is already establishment of the tribunal.
That itself is
tribunal
under
is
challenge before your lordship.
the tribunal-
Whether it is actual, had it been functioning in its proper form,
it's-
whether those
it's a-
matters would have
it's a
been moved at
definite-
all.
It's a definitely. That's why I was keeping mum for 10 minutes. I did not utter a single word. But still one has to consider the realities. One fine morning you cannot come. when we
Considering
can
the
pass-
realities from 1999.
Please, you waited for such a-
1999.
You are coming into 2023 to the
What?
court.
Yes,
Please.
exactly.
Now I am saying, when I have already we have issued a mandamus. And we expect that this mandamus is to be respected. And there is a possibility that in the near future, we have given a 3 months deadline. We expect that within a 3 months deadline, everything has to be done. And the moment all the members are in place, I don't think so there can be any difficulty in this regard. When the matter has already been fixed on 12th of July,
If your lordship kindly hear me
it's not
from here.
expected that we
If
will
your lordship
postpone the
kindly
date
takes the
and say that here and now we are disposing of the
lordship
tribunal
need not to. What I am on.
division bench. If it is says, I'm sorry that I can refer the matter to a larger bench to decide it, that whether this notion of the division bench is correct. At least I can say my brother if joins then.
No, difficulty is, Lordship, kindly be here for 1 minute. This particular.
But ট্রাইব্যুনাল অ্যাক্ট অনুযায়ী যে ট্রাইব্যুনালটাকে এস্টাবলিশ করার কথা সেখানে কোনো কিছু হয়। Then so long that is not there, a person cannot remain remedialist. 226 continue করবে। So act as a whole. I can understand. Here is already establishment is there. Only functional হচ্ছে যে 5 জনের জায়গায় একজন ফাংশন করছে। That's the only problem. Nothing more than that. You can't say it's not functional. It's not functioning effectively. That I can understand. Non-existence, non-functional, and functionally with ineffectiveness is a absolutely different.
No, the only thing what I was.
I can't.
No, Lordship, kindly hear me for 1 minute.
Everywhere you can't be right.
At least I'm right over here.
No.
Because why I am kindly.
Come.
This is what
It's already fixed on 12th of July. Let the matter be taken up on 12th of July
This will never be. This I'm assuring this.
and never to
This
dispose.
will never be, because whenever it comes, it touches that hearing zone, it is relegated to a different date. This I am facing regularly.
And the last week, member secretary have been to the chamber of.
First March means March, April, May. It has to be done within May.
8th May is a date fixed for the last date of application, and 15th May for financial.
I heard to make this particular matter being heard by 3 judges. All of them went away. Kindly hear, have some, kindly appreciate my difficulty from this side. But had this particular situation, I have been answerable to
Mr.
somebody.
Banerjee, in his usual eloquence, have projected the miseries, the plights, and the constraint suffered by his client because of the pendency of the tribunal application for a considerable period of time. Invited the court to deal with the issues being the subject issues involved in the tribunal applications by this court in exercise of power under Article 226 of the Constitution of India. It is vociferously submitted by Mr. Banerjee that the tribunal is non-functional, and the certified copy of the orders passed in the proceeding would reveal that several dates were fixed for hearing of the matter. And he has a strong belief in the system of the tribunal that any direction passed by this court would not be respected nor be adhered to. Stop. Though it is not submitted in express terms that this court should usurp the power of the tribunal and decide decide the said application, but the manner in which the arguments are advanced creates such impression in our mind. When we have been taken to several orders and or decision taken, several orders passed by the court and the decision taken by the authorities, in support of the legitimate right of the petitioners, which according to Mr. Banerjee has been crystallized and attained finality. According to Mr. Banerjee, the indifferent attitude of the different departments of the government has created such impasse, and therefore the tribunal ought not to have mechanically adjourned the matter. Stop. Such being the argument having advanced, we do not agree with the submission of Mr. Banerjee that the West Bengal State Administrative Tribunal is non-functional. There is a distinction between non-existence of the system to the existence of a system functioning with limited capacities. After the promulgation of the Administrative Tribunals Act 1985, with an intent to provide for adjudication or trial of the disputes and the complaints with regard to the recruitment, the condition of service of a person appointed in public service and posts in the union or the state. A specialized institution in the form of tribunal was constituted, was established under Article 323 capital A of the Constitution of India. Section 14 of the said Act which deals with the jurisdiction, powers and authority of the administrative tribunal is categorical to the extent that the said tribunal shall exercise all jurisdiction, powers and authorities exercisable immediately before that date by all courts, within bracket, except the Supreme Court, in relation to the eventualities provided therein. By virtue of the aforesaid provision, initially it was construed that the power of the High Court under Article 226 of the Constitution has been expressly taken away by enacting a law which led several writ petitions to be filed in a different high courts, including the Supreme Court. The Constitution Bench in case of L. Chandra Kumar.
L. Chandra Kumar versus Union of India.
L. Chandra Kumar versus Union of
97.
India reported in
1997.
1997, volume 3, SEC, page 1, 261.
3 SCC.
2 or 3?
3. It was also dealt in the matter.
260. ঠিক আছে? Held কি বলেছি? Held that the powers of the High Court under Article 226 and 227 of the Constitution of India cannot be abrogated nor taken away through a legislative fiat, nor by enacting an act which is subservient to the Constitution and accepted the basic structure theory in upholding the powers of the High Court in this regard. However, it was observed that instead of approaching the single bench of the High Court, it is proper that the litigant must approach the tribunal, which should be regarded as a court of first instance. And thereafter, the approach can be made to the division bench of the High Court under Article 226 and 227 of the Constitution. Such being the law prevalent as of the day, by passing the forum and inviting the division bench of the High Court to usurp the power of the tribunal, if entertained, would not only frustrate the legislative intent, sublime the incorporation or legislative intent, sublime the establishment of the tribunal, but also explore the docket of the High Court, as in every case the litigant would approach the High Court directly or immediately upon filing the tribunal application to decide the main issue. It would not be proper on the part of the High Court to take up all the cases pending before the tribunal and decide the same by itself, when admittedly the tribunal cannot be said to be non-existent or non-functional, but functions with limitations, functions under the limited capacities. We are oblivion of the fact that the West Bengal State Administrative Tribunal is functioning with one administrative member, dealing with the heap of the cases mounting day by day, but cannot accept the contention of Mr. Banerjee that the said tribunal is non-functional. Stop. It appears that the parties have consented the matter to be taken up by a single member of the bench, and in fact, the matters are being dealt with, as one of the order passed by the single member records a further hearing in the matter. And lastly, it has been fixed on 12th of July 2023. We expect and hope that the said single member shall take up the instant matter on the date so fixed, and endeavor shall be shown to bring the litigation to its logical conclusion within 1 month therefrom, in accordance with law. 45 minutes were consumed.
Lordship's the time taken for the order, it could have been relegated. That would have sufficed my
That we intended at the first go. You wanted that you should be heard. Yes, you have a
Had-
right, you have a right to be heard. We cannot deny
I
you
follow,
right
but
of hearing.
Lordship kindly appreciate my
patiently heard
prediction
it.
also. Lordship was this side for quite long. Lordship has
But
faced all these
sometimes
difficulties.
we know where to.
Lordship also faced these difficulties.
Yes, there also I know where to.
I'm helpless at this present juncture.
Anyhow,
And at least this conclusion would be helpful.
yes.
But urgent certified.
With regard to
Great.
Lord, in the morning, Lordship, remember the item number 68, Lordship has not delivered the judgment. But in the meantime, my Lord, I have got hold of the entire instruction. And my Lord, may I hand up to his Lordship so that at the time of delivering the judgment, it would help, my Lord. Because
What you said is there.
yes,
Okay.
my Lord, the instruction is, my Lord, he has already dismissed on 5th of April. And this has been
My client has
communicated to him.
not been communicated.
My Lord, this has been communicated to him, my Lord.
Then we can't take it on record. Then we'll have to. This can't be done at the that you take out from a
My
pocket
client has
something,
not been communicated.
which is you never disclosed it. You never disclosed it
And on
before the
17th, your
tribunal.
Lordship passed the order. Even then, he did not disclose
My
it.
Lord, that is why, my Lord, in the morning, my Lord, I have get. So,
Sorry.
my Lord, instead of passing any order, let it be, my Lord, no, make it not today so that this can be used when Lordship will take up this matter.
Hey, order has to be recalled in the morning. যেটা আপনার কাছে পাঠিয়েছিলাম, recalled. The matter is fixed for delivery of the judgment.
Yes.
Recalled. Place it as for orders in the next month, Monday. Next Monday.
I will file a supplement affidavit.
That is, we can't advise you, do whatever you want to do.
Mal.
What was that matter?
Lord,
Yes, suspension has not been done and he from
Oh,
20.
he is not
You
being
were
allowed
not-
to join.
This doctor,
Despite
the
withdrawal,
doctor.
doctor. Despite withdrawal of the resignation. On 17th, he did not disclose anything.
Well, that's why, my Lord,
Let it come, let it come.
I'm interested.
Any proceeding was initiated?
Yes, that was pending.
no, entire proceedings has been done. Thereafter, this order has been passed. My Lord.
I don't mind like, being dismissed from service, but I am entitled to salary for about 2 years. Nothing has been paid to me.
Let us see.
No. Salary is not finished. I can challenge the dismissal order, but salary cannot be taken away. But the problem is this, my lord. Problem is this, my lord, I tell your lordship. He contested the election. He secured 26,000 votes, the doctor. But that, my lord, gave some impetus to the client, my client, doctor, and my lord, that definitely, my lord, was the cause of problem for the state.
Yes.
That's why he is being victimized. জানি না আমি ডিটেলস জানি না আমি।
All the next.
And I'm for the petitioner, Malad. Malad, this matter is to some extent similar to that of 73, Malad. Delay was there. Malad, the adjournments were taken by the state and on repeated occasions, adjournment was granted as first last chance, then special last chance, and so on, Malad. Yes, Malad, it was transferred to the division bench. And the issue was that
Just, I think, wait till the reopening of this court. And thereafter, if we take up the matter, then in the meantime, they will already be there so that it will be easy for you to secure a expeditious disposal.
my lord, that's all right, my lord. The only thing is that the state should have produced the records, my lord. The point.
It's not necessary. We'll see to it. After vacation, let this matter be listed after the summer vacation.
My lord, this is the affidavit of service.
So let the affidavit of service be filed today, be kept on record. It's called the next.
Right. Oh. Affidavit of service. And this is a case where, my lord, the tribunal passed order where I was not made party. I being the widow, I am entitled for family pension. I was not made party, my lord. And as such matter, I made application, that is can 1, for leave to for writ application before lawsuits. Since there is a judgment of the Honorable Supreme Court.
In a compassionate appointment matter, what
Compassionate appointment matter. This is the family pension, family pension. Yes, main party, yeah.
What? Now, who are the petitioners? Who has
I am
filed the
first
petition?
wife,
You are for the petitioner.
first wife.
So you are
Not made party there. They have taken
oh,
order.
oh, you are the writ petitioner who is for the writ petition.
I am writ petition,
So you are a party.
not party in the tribunal.
Oh, yes.
So I am
Then
seeking leave from your lordship.
approached the tribunal?
Tribunal, not this allegedly second wife.
Who is the respondent number
Allegedly
8?
second wife.
Respondent number 8?
Yes, my lord.
Respondent
He
number
is
8
appearing,
filed a
appearing.
respondent number 8 filed it
Yes, my lord.
and then did not make you a party.
Not made party. And as such, I am seeking leave to file writ, my lord. Writ already.
Now,
filed.
what order has been passed?
My
That
lordship can
entire
conclude.
benefit should be given to you, given to him, her.
That is my lord,
And you are the first wife or a second wife?
first wife. And the application OMO.
Marriage was subsisting when
Yes.
the
No,
second.
still, my lord. My name is in the there. My case was for pension forwarded to the accountant general. Thereafter, my lord, this order was passed. My pension has been not sanctioned due to this.
Yes,
Last marriage took place in 19.
true. And second marriage?
She is telling that in 2010.
And
When my
he died,
son and daughter is
When-
37 years old.
whose
My petitioner number 1 son
is
and
a
daughter, they are 37, 36 years old.
and when he died,
Died in 2018,
18. So,
22nd January 2018.
so
And my case has been forwarded by the
8
department.
years after the LS second marriage.
I have no knowledge.
So that's why I say alleged second
Alleged,
marriage.
alleged.
I say alleged second marriage.
My lord.
So
I'm
how the authority have granted?
No, authority has not given. Authority in my favor. They have. my
No,
lord,
then
assistant-
what is this order? Why you want to challenge it?
Because my lord, the
Release the admissible benefit by passing a reasoned order. It simply says that you pass a reasoned order to whom you will give.
not says one, in where the competent authority of the respondents are directed to release the admissible retail benefit as per the rules by way of passing a speaking order.
Reasoned order with follow-up action
Ah,
and to communicate the
communicated
same
same to
within
period of 8
from the
weeks from the
So-
date of receipt of this order.
So what is this? You had a knowledge because he says that his client already applied And
It is-
you started the process of pension.
It is the expertise order. Losses kindly see. For the state, none. For the state, none. Order last kindly say lordship, yeah. Order.
chose not to appear, my lord.
Why you did not challenge it? So,
And losses kindly come
whatever
to
you are
page 49.
bound by the order. If you have not taken any steps, then you are bound by the order. You can't. So what can be done? If you are not taking prompt steps, then what can be done?
I was informed after 1 year of the order, my lord, because they have communicated in the year 2023. Order passed in 2022. February 2022.
Who communicated?
The respondent number 8 alleged
Communicated to you.
no one lord, communicated to the department.
Then
Not
how
to
you
me.
came to know of it?
Department gave a letter to me that is at page my lord,
So the department
49.
is aware that you are one of the claimant.
Yes, my lord, they have
Yes.
forwarded my case. My losses kindly come to page
Hey,
27.
come tomorrow. First matter. Oh, then come on next Monday from here.
My
We'll
lord,
take up the matter.
my lord. My lord. My lord, losses can pass this order, but the leave granted to file the writ application, my lord. If your losses, please.
My lord, let the petition be taken up together, my lord, next month.
That application may be allowed.
But before that application is allowed, my lord, the documents are to be thrown into, my lord. Let it be, my lord, taken up together, my lord.
Let it come.
Every service tax. এটা তো
I'll get to be mentioned, then a date can be fixed. Yes.